Mr. Collins, when can he come to see you?
Your Honor, have him come see me in Glasgow, at the probation office in Glasgow Tuesday morning.
Tuesday morning.
Yes,
we
sir.
we were offline. The defendant has been sentenced to 12 months on one of the charges and 5 years on the other charge to run concurrently for a total of 5 years, probated for 5 years, supervised with conditions.
Yes, sir.
Okay.
Thank
Be over
you.
there. Did you get that time? Do you know where the probation parole office is?
Yes, sir.
Okay, you be over there in a timely manner. Okay.
Thank you, Judge.
Okay, thank you. Now the victims can, why don't you allow them to go on out? Okay. Okay, as soon as they clear, you can clear, okay? What were the court costs, Matt?
$205.
Okay, you need some time to pay that?
$205. Yes, sir. Give it for everything.
Well, you go ahead and pay $50 a month to get it paid. You can pay it all anytime you want to before then. Okay, $50 a month starting 30 days from today. Clerk's office downstairs. Okay? You need to leave, you say?
I just need to go try to get the paperwork for the Zoom. So
Okay, go ahead. Okay, you can be excused. You can be at the probation parole officer.
Yes, sir.
Okay, now which one of these? Where's the public defender?
It's outside the court. They come in.
Yeah, everybody can come in now. I'm gonna step back here, get the soft drink. I'll be right back.
BJ failed IGA parking lot this morning. I was driving by me. See, like, he called me and I was talking to him. He's like, I'm here at IGA. And then he yells. And I was like, I couldn't see him. I was Don't worry.
Okay, now we have a translator. Where is?
This is the translator for the DPA.
Well, I know that, but I mean, which case, so we can call and get her on the way. Where,
It was Mr. Concepcion, yes.
where's he located?
He contacted our office, said he was trying to make it, but just had difficulty getting in. And soon through the weather, it's hard for us to understand. He said he was trying to.
And also, she said she'd be here at 10:30. Okay, this is their translator. We have a court translator that's not here yet either. And said she'll be here at 10:30.
Thank you.
She did a 4-hour drive.
4-hour drive to come here and the guy didn't show up.
And she asked to appear via Zoom because of the weather, and I told her we needed her in person.
Well, you can't hardly do it,
Yeah.
Well, let's wait till our translator gets here and then I'll release you if his client is not, we'll, just be back available at 11:15. You can go somewhere and get a cup of coffee if you,
I can only be here until 11, Your Honor, because I have 2 hours to travel back for another assignment at 1 o'clock.
well, you just wait around then. As soon as our translator gets here, I'll release both of you, okay? And we'll call the case. If he's not here, I'll do a failure to appear, okay? Okay. You want to come up, young man? You a defendant? See a defendant? What's his name?
Orlando.
Commonwealth of Kentucky versus Orlando Shirley. 21 CR 0096. Are you Orlando Shirley? You're here today for sentencing. Do you understand that? Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Is it correct? Is there any reason why this gentleman should not be sentenced?
No, Your Honor.
Upon plea of guilty to possession, control of substance, defendants will receive a sentence of 3 years, probated for 5 years. Probation be supervised, shall be assessed by social services and follow the recommendations. What are the court costs? $285. You need some time to pay that? I'll let you pay it at $40 a month. First payment is due 30 days from today, okay? And you need to meet with a probation parole officer.
She already had this. He's on for sentencing. So he's already had everything to do with PSI.
Yeah, but when do you, does he have to report to you again, Mr. Collins?
Yes, sir. Wednesday there at the Justice Center, please. Wednesday morning.
Wednesday morning here at the Justice Center, okay? Okay, thank you. What are the court, the court costs, I said 30 days was the first payment today, right, okay. So we don't seem to have any of the defendants present here. So what do we have at PCDC? Pike County, you want to come on and we'll try to get you all out of the way. Thank you.
Yes, sir. Ms. Barnes is right here.
Come. Okay. Ms. Carnes, your attorney is moving to the other room here.
Okay.
Are you already set up back there? Casey County, if you'll turn your camera off, we'll be with you in just a few minutes, okay?
Brittany Carnes, Your Honor.
Okay, Commonwealth Kentucky versus Brittany Carnes, 21 CR 0085. Ms. Carnes, were you born in 1996?
Yes,
What was the last release of your social security?
1313.
Okay, what does the Commonwealth have to say in this case? Okay, they're hooking up right now. You ready, Mr. Stockton?
I am. Thank you for your patience, Your Honor.
No problem. Brittany Carnes, what do y'all have going on this thing?
Your Honor, we'd entered a restitution order so she could pay this off and dismiss it, but the clerk tells me it's not been paid. So I guess I need a negotiation day where she can enter a plea or a trial date.
I'd like to make it a negotiation day.
Okay, February the 11th for negotiation day. The next court appearance is the 17th. Now, is she a prisoner there in Pike County?
Yes, sir.
She's
How
a
long?
state prisoner.
How long will she be serving there?
12 months.
Okay, we just want to put it out for a while, Mr. Stockton?
No, Your Honor, because what'll happen is if we don't have a holder on her or get this case resolved, we'll have to hunt her down. I don't want to go through that again.
Okay.
Yeah.
Okay, well, we'll put a holder on her, have her here on the 11th and the 17th. Do you want her transported, Mr. Stockton?
Well, if Mr. Austin needs to have her set up by Zoom or transported, one.
Yes, I'd like to have her transported.
You
I'll,
submit an order then. Okay.
yes, sir.
Is there anything else up in Pike County?
No, sir.
Okay, well, thank you very much for your courtesy.
Yes, sir.
Have a good day.
Yeah, you too. Let's see, Casey County, you want to come on? Casey County?
Yes, I have Savannah Brennan.
Commonwealth versus Savannah Branham, 21 CR 00126. Are you Savannah Branham?
Yes, sir.
Okay, this is, were you born in 1993?
Yes, sir.
What are the last four digits of your social security number?
6915.
Okay, what does the Commonwealth have to say in this case?
Your Honor, she has a possession case here in Monroe County. She has 2 felony cases pending in Cumberland, motion to a burglary case and a fleeing and evading case. And I guess she needs to get with Miss Costello. I don't know if she's contacted or not. The cases in Cumberland County need to be resolved, and I can run whatever concurrent here in Monroe, but they're the 2 most serious cases.
Well, do you want to transfer this case over there for judicial economy to negotiate? And if you decide not to try.
I think that would be the best if
Yeah,
she would
what I'm
consent
going
to
to
it.
do, what I'm going to do is sign an order, Mr. Austin, if you don't disagree, to transfer this case to Cumberland Circuit Court for the purpose of negotiation. Now, if the Commonwealth decides to try this case separate from the others, we can always transfer it back.
All right.
When is the negotiation day over there, Mr. Stockton?
We have already met for this month, but I will call Miss Costello again. I don't know if she spoke. She usually has the people present live, and then she'll contact the people in jail later. And I've not heard back from her yet on Miss
Okay, well,
Branham's case.
you just submit an order, someone transferring it to Cumberland Circuit Court for the purpose of negotiation. And Ms. Branham, they'll be back in contact with you as to when your court dates are, okay?
Okay, thank you.
Casey County, do you have anything else for us up there?
That's all we have, Your Honor.
Okay, well, y'all have a great day.
You doing
Thank
that?
you very much.
Thank you.
Mhm. Now, Clinton County, are you on there?
Is that one yours? Sorry. I know nothing about it.
Who do you have? Who do you have at Clinton County here?
Ricky Jones.
Identify yourself, please, sir.
Ricky Jones.
Okay, what do we have here, Mr. Stockton?
It's set for a plea today. For some reason, we couldn't do the plea in Clinton County. He said it today, and Miss Hill represents him.
Yes, Ms. Hill has COVID, I believe. And so she asked me to handle this for her.
Do you have the plea agreement there?
I do have a plea agreement, Your Honor. We'll send it over to you.
Okay, this is Clinton Circuit Court 21 CR 00032, 21 CR 00108. You just keep them right there for a second and you can send them in a minute, okay? I already sent them, okay. Just let me have them here. Yes, I am. Mr. Jones, I understand that you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named indictment number 21 CR 0032 and 21 CR 0021?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney?
Yes, sir.
Are you satisfied with the advice of your attorney?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed?
Yes, sir.
You do not have to enter a guilty plea today. You have certain rights of the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel, right to be confronted, cross-examine all witnesses, call, testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, right to require the Commonwealth prove beyond a reasonable doubt that you're guilty of charge against you. That you understand, by entering this plea today, you give up all those rights, and I may consider the Commonwealth's recommendation, but I may apply any range of sentence applied
Yes.
by the law. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. Now, what does Commonwealth say in this case, Mr. Doctor?
Your Honor, I thought I had my files packed and I must have misplaced them. I know it's a 5-year sentence on a felony plea. And I believe it's
I have it right here. Let me,
2.5 years each on possessions, I believe.
let me go over it here. I have it here.
Okay,
It says upon a plea of guilty to possession of controlled substance first degree in indictment 0032, the defendant shall receive 2.5 years. Upon a plea of guilty possession of controlled substance first degree in 108, he shall receive 2.5 years. The two sentences shall run consecutively for 5 years, probated for 5 years, supervised, shall enter and complete the Clinton County Specialty Court, shall receive credit for time served and pay court costs. It's to be determined at sentencing. Is that what you agreed to, sir?
Yes, sir.
Okay. Well, and I have a document here that purports to have your plea agreement. Is that your signature right there?
Yes, sir.
Okay. Well, I'll accept your plea order of pre-sentence investigation court to be done by probation and parole. I'm gonna give you this, take it back over there. And when's our next court date over there in Clinton County?
February the 10th, I think, Your Honor.
You'll be there February the 10th, and then you will sign an order, I guess, having you interviewed for specialty court.
Yeah.
And
I have a question for Mr. Jones. Is Barry Cross interviewed you yet?
No, sir.
Okay, we'll take care of it then. Thank you.
Okay.
Your
Thank you.
Honor,
Yes.
Miss Hill advised me that his mom is having a surgery and that he would request a furlough to be there for the surgery. That's all that Miss Hill told me about it. Do you know when the surgery is?
She'll have to call the Commonwealth attorney and explain it. This is not the forum to do that right now, okay?
Sure,
Yes, Your
yeah.
Honor.
The Commonwealth attorney can call and see what, and whatever y'all can agree to, I'll go along with. Okay,
Get
thank
some
you.
proof from the surgery.
Thank you. Yeah. Okay, that looks like it has all the correctional institutions except Barron County. Is any other correctional institution on there? Okay, let's go to Barron County. Barron County. Now, I'm gonna do something unusual today because of the disruption we had for COVID. I'm just gonna let y'all bring those your inmates up as you want them to, okay? So you call the first one you want, okay?
Thank you, Your Honor.
Yeah.
I'm gonna call Savannah Acosta.
Savannah Acosta. Okay. Commonwealth versus Savannah Acosta, 20 CR 0013. Are you Savannah Acosta?
Yes.
Okay, were you born in 1987?
Yes.
Last four digits, social security number 2299.
Yes.
Okay, we're here on a motion to revoke pretrial diversion. What's the Commonwealth have to say?
Your Honor, she has a 5-year sentence for theft by unlawful taking. She absconded around June of 2021. Also, she has a new trafficking case in Barron County and a new trafficking case in Metcalfe County. I didn't know if she wanted to stipulate or not. I've got Mr. Wesley Bray standing by to testify.
We would like for Mr. Bray to testify.
Okay. Mr. Bray, you turn your camera on, raise your right hand. Swear the testimony about to give us the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
Okay, state your name, with whom you're employed, and what capacity.
Wesley Bray. I'm employed with the Department of Corrections, Probation and Parole, as a probation and parole officer.
Okay, Mr. Stockton, you may proceed.
Thank you, Your Honor. Mr. Bray, have you in the past supervised Mr. Costa?
I have.
And tell the court what happened while you were supervising.
Mr. Costa was placed on my caseload approximately August the 20th of 2020. On 9/4/2020, she came in office or tested positive for methamphetamine. At that point, she went to life skills for treatment, and then fast forward to about April, and she was in life skills. She relapsed again. They had a treatment bed for her in Scottsville, and she was supposed to enter that on April the 13th. On April the 10th of 2021, she was arrested by the Barron County Sheriff's Department before she could go into treatment, charged with trafficking, controlled substance, first-degree meth, hindering prosecution, and drug paraphernalia.
Okay, while we're on that charge, is that charge still pending?
It is pending. Her bond has been revoked on that charge. So
Okay, and is that a circuit case now in Barron?
It is a circuit case. It is a circuit case, sir.
Now go ahead. I'm sorry to interrupt.
And then she got out in June after she was charged in April. She got out in June of 2021. At that point, there was some discussion about maybe putting her in drug court, but we found out she wasn't eligible to drug court because trafficking is a Class C felony. It would have to be amended down to a Class D to make her eligible. So at that point, last contact I had with her was on June the 30th. She absconded. Warrant was issued in August for absconding. Then on 9/24, September 24th, she was arrested in Edmonson County after pursuit. She was arrested in Edmonson County and charged again with trafficking and drug paraphernalia and tampering with physical evidence at that point. After that, a bond hearing was held in Barron County. Her bond was revoked in Barron County on her Barron County case, and she's been in jail ever since the 25th of September.
Have no other questions, Your Honor.
Mr. Austin, would you like to ask any questions?
I have no questions for Officer Bray.
Okay. You have any witnesses you'd like to put on?
I do not have any witnesses to put on.
Okay, I revoke the pretrial diversion and schedule a pre-sentence investigation report to be done by probation and parole and appear here for sentencing on February the 17th. Thank you very much. Okay, next case. Identify yourself, please.
Crystal Watts.
Okay. Commonwealth, Kentucky versus Crystal Gail Botts, 21 CR 86. Are you Crystal Gail Botts? 1977. Last four digits, social security number 6863. We're here for a pretrial conference. What do you have to say, Mr. Commonwealth Attorney?
Sent plea papers. I don't know if she signed them or not.
Yes, she signed the papers. She signed them. Did you send new ones or are they the same ones as you sent prior?
Yeah. Now there's an issue that's come up since I sent those plea papers that Mr. Austin's not aware of. Her case, she had a case that was going to go to grand jury this morning before I had to cancel it. So I don't know if he wants to wait until she can try to wrap both of these cases up or not. Or if you want to go ahead and enter the plea, but I'm not going to be bound on anything else.
Yeah, let's try to wrap these both together since there's a new one coming up. I would like
We could set it on February the 11th. If we work something out, we can do an information indictment on the other case.
All right.
That way she wouldn't have to wait.
February the 11th for negotiation, next court appearance on February 17th. Okay, thank you.
Are there any way that I can get out of jail?
No,
Because I'm in here on contempt.
no, you'll be here on the 11th and 17th, and hopefully wind everything up on the 17th.
Okay, thank you.
Yeah. So you got next, Barron County. Could you identify yourself, ma'am?
My name's Crystal Nip.
Last name is what?
Crystal Nip.
Would you be under Crystal Hall? on the
Yes,
document?
sir. Yes, sir. Sorry about that.
Okay, whoever's online under.
That's Ms.
CH.
Ford. She's a witness, Your Honor, in this revocation.
Okay. Commonwealth versus Crystal G. Hall, 18 CR 00165. Motion to revoke pretrial version. What's the Commonwealth have to say?
Your Honor, this is basically failure to cooperate with the probation officer. It's a 3-year sentence on possession. I'd need Ms. Ford to explain what's going on.
Ms. Ford, you raise your right hand, please. You swear the testimony you're about to give us the truth, the whole truth, nothing but the truth.
Yes, I do.
Could you identify yourself and with whom you're employed in what capacity?
Charity for Probation and Parole, District 3. I serve as officer for Metcalfe County.
Okay.
Ms. Ford, have you been supervising Ms. Nip for some time?
Yes, I have.
And what's been the problems you've experienced in supervising her?
Since I've been supervising her, she's had a recurrent problem with substance issue for use of meth. She tested positive November the 5th, 2019, January the 7th, 2020, December the 2nd, 2020, July the 19th, 2021, and just recently on 12/2/21, she signed a teacher form.
Go ahead. I didn't mean to interrupt you. I was going to ask you if if you tried to get her any treatment.
She's met with our clinician 11/7/19, 1/10/2020, 10/13/2020. She completed life skills outpatient. She was ordered again by the SSC 12/10/2020 to go back. She met with the SSC again on 8/12/2021 and again on 12/17/2021. Each time the SSC meets with her, she just recommends her to do outpatient and to continue with NA and AA meetings. She also has an issue with maintaining employment. We were in court maybe a year and a half ago for this same issue. She did well for a while. She also has recently picked up a new felony arrest where she's being charged with trafficking controlled substance, methamphetamine, drug paraphernalia, and possession of marijuana. She's scheduled to be back in Metcalfe County Court on February the 22nd for a pretrial conference.
Okay. Now you said she'd failed to cooperate with you. Is that before she wouldn't report to jail when she's supposed to?
Yes, she didn't show up when she was supposed to. She was released by accident. I contacted her and told her to get there by a certain time. She didn't get there by that time, but she did actually show back up at a later time on that same date.
So I guess the basis for the revocation would be her repeated use of methamphetamine.
And the pending felony.
And the pending felony. Okay, thank you.
You're welcome.
Okay, you have any inquiry? Mr. Austin?
When was she arraigned for the new felony again?
She was arraigned on 12/14, and they set it for a pretrial conference on February the 22nd.
And do you know approximately how soon after late that she did turn herself in when she was mistakenly released from the jail?
I mean, I'm not exactly sure, to be honest. I mean, the jail would know exactly when she booked back in, but I don't know. I just know that they let her out on the 15th by mistake. I called her on the 16th and told her to be there by 10. I think she reached out to you and said she couldn't be there. And then I think it was later midday or something she got there.
I have no further questions, Your Honor.
Nothing further, Your Honor.
Hey, do you have any witnesses you'd like to call, Mr. Austin? Mr. Austin, would you like to call any witness?
No, I'm sorry. I have no witnesses at this time.
Okay, I will revoke the pretrial diversion. Ask the precinct's investigation report be done by probation, parole, and have sentencing on February 17th.
Thank you, Your Honor.
Thank you. Now, I'm going to have, going back here to the courtroom here just for a second. What's the gentleman's name here? Lopez. Conception Lopez Yanez. I know. Did y'all check where our interpreter is? And has our interpreter been in contact with y'all? What, you got a phone number on her? What? Yes or no? You got a phone number? I can't understand you. Okay. Okay. Well, we have one interpreter here, the AOC interpreter is not here. You're the public advocacy interpreter, correct? I guess we can try to proceed the best we can. You want to come around, let me swear you.
Am I interpreting? I'm not interpreting for the court today, so I'm only here to conference the case in private between Mr. Concepcion and his attorney.
Pull it up over your nose. Can you tell him pull it up over his nose? Okay, well, I'll continue. What's his bond condition here? What we doing for him on a pretrial conference?
Your Honor, this is a case which involves alleged drug possession. There's no lab of that. And I hate to keep running these interpreters back and forth. If he wanted to do a misdemeanor plea and get it over with today, I did.
No, we can't do that because she can't interpret it for him.
We have an interpreter on the way.
Well, we don't know when the interpreter's gonna get here. They said they were gonna be here at 10:30.
She's leaving late.
Huh?
She's supposed to leave late. So
And this interpreter is leaving at 11, so.
What would the misdemeanor plea be? And the
12 months to 2 years, $250 fine.
supervisor, 2 months, me and her can go and relay that.
I can't take the plea if I don't have an interpreter here.
If we conference the case and he agrees, do we offer them when your interpreter gets here?
I don't know my interpreter's gonna get here. You know what I mean?
If we do the plea, I mean, if I get the paperwork, and they conference together, and we have an agreement, if she need to show up the next time or just have a court order next time in the plea.
I would not have to show up unless counsel wants me present. If we have already conferenced the case and he knows what he's doing, actually, the court interpreter can relay also an offer, but the court interpreter cannot discuss the case in itself.
Yeah, well, I had a case like that one time where I was sitting as a special judge and I had a dispatcher was supposed to be acting as an interpreter and was actually talking the defendant into entering a plea after I got it translated, you know, so. And then do what? On her way in. Okay, she's here. Are y'all talk real quick here, see if she's gonna take off. Wait. Hello. You want to come around and let me swear you in? You swear that you are a lawfully licensed interpreter in the Commonwealth of Kentucky and your interpretation has been accepted in the court by the administrative office of the court, that you will faithfully translate all matters that you hear in the Monroe Circuit Court. Okay. Okay. You want to come around, sir? Commonwealth of Kentucky versus Concepcion Lopez Yanez. 21 CR 00109. Now, prior to the interpreter coming today, an offer was made to you by the Commonwealth. And you've had an opportunity to consult with your own interpreter concerning this offer. Counselor, has your client decided whether he wants to accept the offer or not?
Yes.
Okay, now. Okay, now we'll have to draft the paperwork, but will it be necessary for the paperwork to be done in Spanish also, or can it be read to him when it's done?
I believe the court interpreter can translate translate the document, Your Honor. Yes, Your Honor.
Okay. Okay, now, so he wishes to enter a plea. We'll have the paperwork done. Now, your translator has told us that she has to leave at 11 o'clock to go to another appointment. Is that correct, ma'am?
Yes, Your Honor.
Okay, have you had all the opportunity you need to discuss in your native tongue the matters before the court now?
Yes.
Okay, I'll let the Commonwealth announce what the agreement is so he can hear it while you're still here. All right?
It would be misdemeanor plea, possession of controlled substance, second degree, 12 months, probated for 2 years, supervised, $250 fine.
And court costs. Okay. Court costs would be what, 200?
240.
The fine was what?
250.
So it'd be combined court costs and fine of $490. And I would allow him to pay that at $40 a month, starting 30 days from today.
Your Honor, I apologize. What was the amount?
$490. That would be $250 fine and $240 court costs. I will allow him to pay it $40 a month, starting 30 days from today. Now, do you desire to discuss any of this with your attorney and with your interpreter before I excuse her?
No.
You may be excused. Do you have anything for me to sign, or they sign it for you now, right? You're working for it.
No, Your Honor, just the order.
I sent a chapter 31.
You'll have to submit me another copy. I'll sign it as soon as you get.
Send it to me.
Okay, thank you. Be careful out there, okay? Okay, now, we'll have to draw the paperwork up. It'll take a few minutes and then we'll call you back up, okay? You just take a seat back out in the crowd. Okay. Let's go back to Barron County.
What's the charge?
Possession of controlled substance.
I need to get a, what, file code. Who, Yanez, Concepcion, Yanez. Maybe just start with the Y.
Access ZBA on December 28th.
Okay, who do you have up next?
Tyler Brown, Your Honor.
Mr. Austin, our files indicate that order for the interpreter was sent back to you on December the 28th. So you have it there somewhere.
All right, I will look for it, Your Honor.
Okay. State your name, please, sir.
Tyler Brown.
More clearly.
Tyler Brown.
Brown, okay, thank you. Commonwealth Kentucky versus Tyler I. Brown, 21 CR 0047. Are you Tyler Brown?
Yes, Your Honor.
Okay, you're born in 2001.
Yes.
Last four digits, social security number 2961.
Yes, Your Honor.
Okay, we're here for a pretrial conference. Do y'all have anything to announce?
No, Your Honor, as far as the plea, Mr. Bell just got in the case. If you want to set this for negotiation day, I will on the 11th.
Negotiation on February the 11th and the next court date on February the 17th. Okay,
Judge,
thank you.
may I address bond on his case quickly, Your Honor?
Sure.
Your Honor, Mr. Brown, I think, was out on bond that got revoked. I have spoken with his family, Your Honor, and I'd asked the court to reinstate his bond. He does have a job waiting on him.
What was the revocation about?
Your Honor, we had attempted to do two different pleas that he backed out on, and then you found out that he wasn't calling in the pretrial like he was supposed to.
Yeah. Yeah, well, we'll see him on the 11th and the 17th. Okay, next, over in Barron County.
I have Mr. Jesse Hendricks.
What's the last name, sir?
Hendrick.
Hendrick. Commonwealth Kentucky versus Jesse Hedrick, 20 CR 0032, 21 CR 00121, and 18 CR 00162. Are you Jesse Hedrick?
Yes, sir.
Okay, we're here on a motion to revoke on 32. A pretrial conference on 121 and a motion to revoke on 162. What do you have to say, Mr. Stockton?
We negotiated out a plea where he would plead guilty to 21 CR 127. He wouldn't be revoked in the other cases, but he would have 5 additional years and he would have to complete the Monroe Specialty Court program. That's a felony plea.
What was the number that he was pleading guilty on?
21 CR 127. 121, I'm sorry.
Okay, I didn't have 127, so.
There's a typo in the plea paper.
Okay, no problem. A motion has been tendered, sir, that says you wish to enter a guilty plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that's indicted in 21 CR 00121?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence of the case and you feel like you're fully informed?
Sir.
Okay, you have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, the right to part of the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you, that you understand that by entering a guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I also may apply any range of sentence allowed by law. I do not have to accept the recommendation. Prior to accepting any recommendation, I will wait the pre-sentence investigation report. Now, this is a felony plea. Is that correct, Mr.
That's
Stockton?
correct, Your Honor.
In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you will have the right to withdraw your plea. Now, I want you to listen very carefully to what the Commonwealth says the plea offer is, Mr. Stockton.
Your Honor, Mr. Hedrick will plead guilty to theft by unlawful taking over $500. He will receive a 5-year sentence, probated for 5 years with the balance supervised. He will also, this will run consecutively to 18 CR 162 and 20 CR 32. He will pay restitution in the amount of $150 within 30 days of final sentencing, and he'll enter and complete the Monroe County Specialty Court Program.
Is that what you agreed to, sir?
Yes, sir.
Has anyone, including your attorney, threatened you in any way to get you to enter this plea?
Yes, sir.
You're entering this plea because you are guilty and for no other reason.
Yes, sir.
Okay. Knowing your constitutional rights I've explained to is still your desire to enter this plea and allow the court to fix your punishment. Do you realize that by entering this plea, you have another felony conviction that could be enhanced if you have another felony in the future?
Yes,
You
sir.
understand? Okay. These documents are not signed here, brother.
Which I swear I thought they were, saw him yesterday and signed them. Must have picked up the wrong ones or something. Thought he's. While she's getting those back to me, because I swear I thought we signed all of them. I was there with him yesterday and I read them to him, but Mr. Stockton, he also had a question that I didn't know what to tell him. He was wondering when the drug court orientation would be.
Well, it'll be after final sentencing. It should be within the next week after that.
Oh, that's the one he didn't sign. All right. Oh, can we?
It'll have to be assessed and voted on, but it should be within a month.
Can we fax this to the jail so that they can have him sign it and bring him back up later, Your Honor? I'm sorry I made that mistake.
Okay, well, send it over, Mr. Hedrick. Okay, Mr. Hedrick, we'll come back to you. We don't have your signature on plea arrest. They're going to fax it over there to the jail, okay?
Thank you.
Okay, next,
Jason Law.
Commonwealth versus Jason D. Law. Are you Jason D. Law?
Yes, sir.
This is 21 CR 0021. We're here today for sentencing. Also 21 CR 0022. No, that's not correct. Just 0021. Okay, have you had an opportunity to look at the pre-sentence investigation report done by Probation and Parole?
Yes, sir.
Substantially correct.
Yes, sir.
Any reason, Mr. Austin, that this gentleman should not be sentenced?
No, Your Honor.
On a plea of guilty to fleeing and evading police officers first degree, the defendant shall receive a sentence of 10 years. On a plea of guilty possession of controlled substance first degree, the defendant shall receive a sentence of 3 years. The 10-year sentence and the 3-year sentence shall run concurrently for 10 years to serve 180 days in jail with the balance probated for 5 years supervised. He shall receive credit for time served. What is the court cost in this case? 155. The court cost is 165.50. I'll allow you to pay that at $30 a month, commencing 30 days after you're released. Okay?
Yes, sir.
Okay, thank you very much.
Zachary Law.
Okay. Commonwealth versus Zachary Law. Are you Zachary Law?
Yes, sir.
Birth date 1997.
Sir.
Birth year 1997.
Yes, sir. Yes, sir.
Okay, somebody needs to hold it down a little bit there. You're keying the microphone. Thank you. We're here today on a pretrial conference. What do you have on him, Mr. Stockton?
He had some co-defendants, and Mr. Austin and I have discussed this case, but we'd like it to be on the negotiation day on the 11th.
You should be on negotiation day on February the 11th. Your next court date's on February 7th. Okay. Thank you very much. Next up.
Terry Muse. In here. Okay. Gary Norris.
His attorney's got a trial today.
Exactly.
Versus Gary Norris. 19 CR 0110. Are you Gary Norris?
Yes.
Okay, for sentencing, you understand that? You had an opportunity to look at the pre-sentence investigation report done by Probation and Parole.
Yes, sir.
Is it substantially correct?
Yes.
Is there any reason this gentleman should not be sentenced today?
No, Your Honor.
Is possession of controlled substance the only charge he's to be sentenced on?
Yeah, it's fine.
That is correct, Your Honor.
Pretrial diversion having been revoked, a pre-sentence investigation have been received. Court finds that he should be sentenced to 3 years.
We would like to address probation.
Okay. Would you like to explain why the court should consider probation at this time when he just got revoked on a pretrial diversion?
From what I've been, from what he tells me, the reason he was not in contact.
He needs to tell somebody. You can't
All right.
testify.
I'll let. Would you like to testify, Mr. Norris?
Yeah.
Well, raise your right hand, sir. Swear the testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes.
Okay, state your name and respond to the questions of your attorney.
Gary Norris.
Okay, Mr. Norris, thank you.
Mr. Norris, could you explain to the court the reason you failed to stay in contact with probation and parole?
Yeah, I didn't have no way there to see.
What? Why was that?
My ride. I had no phone.
Where were you at and what were you doing?
I was in Tompkinsville.
If you were to be released, would you have work lined up?
Yes.
And where would you be living?
In Tompkinsville.
With who?
My mother.
And
Okay, Mr. Stockton, do you have anything?
Yeah, where will you be working at, Mr. Norris?
The pallet mill in TV, Tompkinsville.
I'm sorry, I couldn't hear you.
It's pallet mill in Tompkinsville, Kentucky.
Were you working before you got your probation revoked?
Yes.
Okay. Have you had any problems with drugs lately?
No.
Okay. I don't have any more questions.
Well, he had a pretrial diversion, didn't he? Is that what he had?
He did, Your Honor, and he absconded. He was gone for about 8 months. And I might look, I'd agree, maybe shocked.
But he was in
Yeah.
Tompkins. So,
Well, I
mean,
had to get him,
that
he was in Lafayette, Tennessee, is where he was. That's where he's showing up on my computer program.
that was where I thought he was too.
Yeah. But
Well,
maybe
Mr.
he was
Austin-
here. I don't know.
Mr. Austin, you don't need to pile on your client and make him a perjurer.
But I'd agree to look at shock, but I'm opposed to probation.
All right.
Well, we'll consider shock probation, so I'm going to sentence you to the 3 years. We'll deal with the other thing later. Okay, next.
Jesus Padilla.
Jesus Padilla.
Yes, sir.
Are you Jesus Padilla?
Yes.
You born in 1982?
Yes.
Now here, have you seen this pre-sentence investigation report done by Probation and Parole?
Yeah, I see.
Have you seen it?
It was the document we,
Yes, I see.
Have you reviewed this pre-sentence? Wait a second. Have you reviewed the pre-sentence investigation report?
Yeah, uh-huh. That's what he asked. Did you read it? Yeah, I'm sorry. Yeah, I'm sorry. I'm seeing. Yes.
I showed it to him and he told me he could read very well, so I read it verbatim to him yesterday.
Yeah, 2 days ago.
Mr. Padilla, do you understand the English language well enough to have understood when he read this thing to you? Did you understand what he was saying?
Yes, sir.
Okay. Is there any reason why you shouldn't be sentenced?
Yeah.
Okay. On a plea of guilty under indictment 0068, receive a sentence of 5 years. Plea of fleeing under 069, 5 years. 69, evading police, 5 years. 2 5-year sentences shall run concurrently for a total of 5 years. Upon a plea of guilty under 69 for failure to maintain insurance, should pay $1,000 fine. Under 068, the 5 years under 069 and 068 shall run concurrently for a total of 5 years, serve 104 days with a balance probated for 5 years. the one pleaded guilty to assault, 4th degree, 2 counts, shall serve 180 days. Now, it doesn't say whether the 180 days starts today or is in addition to 104.
He would get credit for time served, would be my recommendation.
So the 104 and 180 would be running concurrently with each other,
Yes.
correct? For a total of 180. He's got his probated time and serve 180.
Yes.
Okay, and the court costs and fines, the fine is $1,000. What's the court cost? $1,365. And I'll allow you to pay that at $75 a month, starting 30 days from today. Do you understand that, sir?
Yes, sir.
Okay. Okay, now he'll need to meet with the probation and parole officer to give them contact information. All right, is probation parole still online here?
Yes, Your Honor, I'm here.
Okay, when does he need to contact you?
As soon as he's released, if he's released tomorrow, he needs to report to me next, obviously he can report to me next Tuesday in Barron County.
Okay, next, has he got his 180 days in?
From my count, I believe he does.
Well, the defense attorney says he has it in, so. Well, the pre-sentence investigation report says, could you check on that, Mr. Collins, see how many days he's got in?
I will. I can check on it right now.
Okay, hold on while we got you here.
Yeah, it's okay. He's 100 a day, 100 a day. I'll go home. I'm ready.
Bear with me.
Like 2 days ago, this I go
Your Honor, I'm showing him with 144 days per PSI rider.
Okay, so you got a few more days. Okay, so as soon as those days get up, he'll need to be given, how many more days? That's 16 more days? How many, 26 more days? What was it?
36.
36.
Okay, okay, well, thank you very much. I'm going back now to, I'm going back now to Concepcion Lopez Yanez.
We all want to do that.
I'm sorry. Mr. Stockton, you want to come out here? I'm going back to Mr. Yanez.
Yeah, Mr. Carter will be there shortly, please.
Okay. You drove 4 hours to get here? Where from? Trigg County, down the flatlands. Were the roads pretty clear? Oh my God, no. You didn't come 100, Highway 100. Yeah, well, I wouldn't go back that way. But if you do go back that way, they got a nice little diner down there. You need to go from here to Glasgow. Okay, and the officers will tell you how to get there. You just go straight out. There's a wonderful improved road. You can get to Glasgow that way, and it'd be a lot better trip back.
I appreciate it.
Okay. Mr. Yanez, you've had an opportunity to look at the plea agreement.
I haven't really had a chance to read it, but my attorney went over it with me. And I'm going to plead guilty, but can I read it now?
Yes, it should. Yeah, just let her read it to him. How long is it? Mr. Austin, have you forgotten something?
If I pay the entire amount of the fees and what I owe, will I be done with it? Or do I still have the supervision?
No, the supervision will be for the time period. They're two separate things.
That's fine. I mean, I thought if I paid the amount all at once and have the money together and everything.
How long is the supervision?
The supervision could be for the
What-
full time.
Well, how much, just tell me how much it is.
2 years, but there's a clause saying it will last until it is outside of the family. And after that, it'll be up to the family.
How long is the supervision period, Mr. Hornash?
2 years.
I'm gonna tell him that if he pays it off, I'll end the supervision at 1 year. You tell him that if he pays all his fines and costs and everything, that I will end the supervision at 1 year.
And that's fine, but how long will that have?
Well, he's got, what's the total on the thing? What was the total on it? Madam Clerk, what was the fine on it? Yeah, 250 and 250 and 240, 490. And I told him he could pay it at $40 a month, I believe, didn't I?
Yes. I could pay half and half.
Well, I don't, he doesn't have to pay half and half. He can pay $40 a month. Or he can pay it all. Or he can pay a fourth of it. I don't care, as long as he pays at least $40 a month. Is he already entered the plea? You know, I've gone through this. I don't even know. I forget.
So it's 1 year, he pays it all, correct, and then instead of 2.
I'll let it be unsupervised. I'll let him be unsupervised after a year after he pays it off. But he'll still be on probation for 2 years. Is that right, Mr. Carter?
I understand.
Okay, this is a misdemeanor plea. You still have certain rights of having, I'm completely discombobulated on where I am on this thing because we've had to stop 4 or 5 times.
I read the first page.
Yeah, would that include his rights on there, right?
No.
Go read him his rights.
Your Honor, I apologize. I am not sure how to interpret in this movie.
It's the same under, the same word would be under English or Spanish, I'm sure. It's a chemical. You don't believe that?
I do. I would normally look it up on the phone.
Well, he knows what it is, so. Ask him if he knows what anhydrous ammonia is.
Your Honor, may I get my phone, please?
Yes. That's a component of meth, isn't it, Mr. Carter?
You know, Your Honor, I don't know that. I
believe it is, Your Honor. I believe
Depending
on what version of meth you're making. I also believe it's a commonly used fertilizer. that-
I know what it is. Yeah. I don't know where we are in the plea agreement, where we got that in there.
That is paragraph 10.
It's not in the law.
If it's not in the offer, you don't have to worry about it.
None of this is in the offer. She's ready. But her rights, his rights.
Yeah. Okay. Ask him if he understands his rights, as read, Jim. And he still want to enter a plea and allow the court to fix it pursuant to the agreement. And Mr. Carter, I want you to read the offer one more time, just the offer portion of it.
Your Honor, on a plea of possession of controlled substance, second degree, the defendant will receive 12 months probated, 2 years, credit for time served, pay costs.
Okay, you need to stop every once in a while when someone's interpreting
I'm
something.
sorry.
Okay,
I have it written down.
okay.
Pay costs at the court's discretion. active supervision until costs are paid, and contraband destroyed.
Okay. Is that what you've agreed to, sir?
Yes, Your Honor.
Okay, well, I'll go ahead and sign a misdemeanor judgment today. You will not have to come back for any additional sentencing. And I guess there's a number. Chase, are you still on there with probation and parole?
I am, Your Honor.
This gentleman's going to call you, but he'll need an interpreter.
I've got some other individuals on my caseload that may be able to speak Spanish, so I may have to have them report at the same time as him. So we'll figure out a way.
Yeah.
If he can just report to me
You
next.
want to give him, let me ask you, why don't you give him a time certain so you can have somebody available?
Next Wednesday at 9 a.m. Here at the Justice Center.
You put that on his little piece of paper next. Here at the Monroe County Justice Center,
Yes, Your Honor.
Wednesday, 9 a.m. here at the Monroe County Justice Center.
Yes.
Okay.
And Your Honor, you guys indicated that his boss speaks English and can call him.
Well, he's supposed to be here in person. And he can bring someone with him if he wants to. That's when she goes back to Bowling Green. She's gonna go down 65 and take the exit to Owensboro and then go on the Russell Road. Yeah. It won't take her an hour, 45 minutes to get back to Trigg County, but maybe 2 hours. Okay, thank you very much. Is there anything you want me to sign or are you good? Okay, okay. The officer here is going to give you direction. You're going to be back home in 2 hours and 20 minutes, I guarantee. Okay, thank you. Okay, let's go back to Barron County Jail. You got your chauffeur with you today there?
I'm getting ready to go back on.
What's your name, young man? Welcome to Monroe County. Okay. Okay, who do we have there?
Danny Pippin.
Okay, let me see what I can find you here. Danny Pippin.
Yes, sir.
Okay, this is 21 CR 0045 and 21 CR 0046. We're here for a pretrial conference. Is this your case, Mr. Bell?
Yes, Your Honor. I thought we were on for final sentencing today.
No, we had this up for sentencing. The judge rejected the plea and we were going to meet on it when the bad weather hit and I didn't show up. The last motion. If you want to set it for the 11th, I'll be glad to discuss it with you. And see if we
For
can-
the 11th for negotiations and then.
That's what happened. On it.
And then on the 17th, okay? Thank you very much. Okay, now next.
Tanisha. We have Tanisha Shirley.
Commonwealth, Kentucky versus Tanisha Shirley, 18 CR 00192. Are you Tanisha Shirley?
Yes, sir.
Okay, we're here today for sentencing. Have you had an opportunity to do the pre-sentence investigation report been done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Is there any reason why this lady should not be sentenced today?
Judge, not that I can think of. I would just ask that the court abide by the sentencing recommendation set forth by the jury.
I don't see it on here. I don't see it in here. I think the sentence was five years on the felony case, 1 year on the misdemeanor case, $500 fine and court costs. Of course, the felony and misdemeanor will run concurrently. What does the court cost?
Judge, oh, I'm sorry.
Well, you go ahead.
I was going to ask, I understand the jury did impose a fine, given that it is a sentence to serve. I'd ask that fine and court costs be waived for Miss Shirley. She is indigent, will be incarcerated.
I'll give her some time after she gets out. Don't worry. Could be $710 and she can pay it at $50 a month, starting 30 days after she's released. Okay. Okay. Well, thank you very much.
Thank you. Simmons, Michael Simmons.
Commonwealth versus Michael Brandon Simmons, 21 CR 00123. Are you Michael? And also 20 CR 0055. Are you Michael Brandon Simmons Jr.?
I am, Your Honor.
You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by Probation Parole?
Yes.
Is substantially correct?
Yes, sir.
Counselor, is there any reason why this gentleman should not be sentenced today?
No, Your Honor. I would like to address probation.
Okay. Go ahead.
Mr. Simmons has expressed to me that he would really like to start paying on his restitution. He has also expressed that he still has a case.
You want to allow him to testify here?
Would you like to testify, Mr. Simmons?
Yes, that's fine.
Raise your right hand, please. Swear a testimony about to give us the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Go ahead.
Mr. Simmons, do you have any matters still pending in Colorado?
Yes.
And is it just the sentencing portion that you were?
Yes, just the sentencing portion is was stuck in Colorado. I was due to be sentenced in Colorado whenever I was on my way down to get things squared away with my family and stuff in Tennessee. And then on my way back to Colorado, I was detained on this case. And I'd already had been detained before in Colorado, but Colorado has set a bond. I made bond, and then Kentucky, the Commonwealth of Kentucky, never contacted Colorado about a court date or anything like that. So I had
All right,
Mr.
Simmons.
Wait. I don't know about any of this, and he can't prove any of this. So if he wants to tell me why he should be probated, he can.
Do you intend to go to Colorado, right, to get that case squared away?
Yes.
And the outcome of that is to put you into, tell me what the.
I really don't care about that. Okay, it's not within my province.
All right.
Okay?
He wants to pay restitution.
Well, I'm sure, and he will. He'll pay restitution, okay?
Yeah.
Okay, Mr. Stockton, what do you have to say?
Your Honor, Mr. Simmons' credit is not good at my office because we attempted to extradite him from Colorado. He refused extradition. We had to get a governor's warrant in Colorado twice because Colorado released him. He never would appear in Kentucky without being detained. He owes the county about $1,000 for going and getting him. He owes Junior Smith about another $1,100 for stealing his ankle monitor. So I don't think he should be rewarded for that.
On plea guilty of a tampering, he receives 3 years to serve. And if he were to pay restitution in toto to everyone else, I would consider shock probation. You agree with that, Mr. Stockton?
I do, Your Honor.
Okay.
In
You
full.
understand what I'm saying? If he pays in full the restitution to the county and to the monitoring company, then we'll consider shock probation. Okay, thank you very much.
Yes, Your Honor, I have one question.
You need to ask your attorney.
Robert Nelson, I have one question.
All right.
No, you need to contact him later.
I will.
It's just about the days credited for time served since I've been in here. I'm not.
He'll talk to you about that later. He'll talk to you about the call.
I will come and talk to you about.
Kayla Spivey, is that Nick? Who's
Right.
next? There.
Yes, Kayla Spivey.
Make a note of that for me.
Yeah.
Commonwealth versus Kayla Spivey, 20 CR 0084. Are you Kayla Spivey?
Yes.
Okay, you're here on the pretrial conference. Mr. Garrett, do you represent her?
I do, Your Honor, and we've also got a motion, Judge, for a bond reduction.
Okay.
Judge, I would ask the court to consider setting her at $1 million cash bond at 10%. She does have family that's capable of posting a 10% $1 million bond. She has been incarcerated since October of 2020. And one of the problems we have with this case, Judge, is there's a co-defendant who is stuck in California. There's been a governor's warrant signed by the California governor, but that's not been effectuated. He's being held in a facility out there. So until he is capable of coming back to stand trial, I think it's going to be very difficult for us to move forward. She would abide by any conditions the court imposes upon her, including an ankle monitor or any other conditions the court deemed appropriate.
Your Honor, the Commonwealth opposes the motion on the most obvious of grounds is that she has proven to be a flight risk. Yeah, I'm sure that the court's aware of the gravity of the charges in this case. She's indicted by the Monroe County Grand Jury for being complicit in 2 murders, executions, really. And quick as the law got on their tail, she fled with the co-defendant to California. And she did voluntarily come back without fighting extradition. But all the proof that I'm aware of shows that she voluntarily left, that she voluntarily abandoned her children in the course of doing this. And that tells me that if she had the opportunity to flee, she would do it. Now,
how's the extradition going?
Mr. Stockton will have to answer that. It seems to be caught up into the bureaucracy of the state of California. Either that or, in my opinion, which is just that, and that used to get you a cup of coffee in 50 cents, but now it's more like $2. I don't think California wants to send anybody back to Kentucky who possibly it would be facing a death sentence. And in this case, although has been no notice given, that certainly would not be out of reason to do so. Again, establishing the gravity of this case. Now, let Mr. Stockton address the California status.
Your Honor, there has been an executive agreement with the governor of California and the governor of Kentucky, and my understanding is that somehow the local prosecutor in California has gotten involved and has put a hold on this. I don't know if Mr. Whitledge has other crimes that they're investigating. That's my suspicion. I think California will have to do one thing or the other. By October, he's due to be released, I believe. So they will have to extradite him then unless there's new charges. Now, if it comes down to it, I guess we can try Miss Spivey separate. We can always set her for trial and try her. So I'm not wanting to hold her case up because of Mr. Whitledge at this point in time. I have in the past, but I have no guarantee when he'll be here. So if she wants a trial date, we can set her a trial date.
Mr. Garrett, you want a trial date?
Judge, I think what I'd want to do before we set it for trial is maybe set it out another 30 days to see if we can determine the status of Mr. Whitledge. I would add, Judge, I know that they said that Ms. Spivey is a flight risk. I would
I'm
say.
not going to let her out right now.
Okay.
She is accused of being complicit in 2 murders and leaving the state. She did come back, but she wouldn't come back if she hadn't got caught. So.
Judge, I guess I could say that, it was.
You can't say anything that'll change my mind about that right now, because I'm gonna give her a speedy trial. And that's the reason I asked the other question. It's not fair to her to wait upon someone else fighting extradition and be incarcerated. And I think the Commonwealth has acknowledged that, at least tacitly acknowledged that, the fact that they'll proceed with her case if that fella successfully uses the circumstances that California presently finds itself in to prohibit them from complying with a lawful request from the governor of the Commonwealth of Kentucky. So that'll be handled on another day and probably not in this court. So I will have her back here on February the 17th, and maybe we have more information and then we can set her a trial date. Okay.
Thank you.
Very much. Yes. Do you have Benjamin Tooley there?
He's in a COVID cell, Your Honor.
Okay, well, we'll wait. Who do you have right there?
Michael Vibbert, sir.
Mr. Vibbert, is that correct?
Yes, sir.
Michael S. Vibbert, 21 CR 00127. Mr. Vibbert, you're here on an arraignment. You have the right to remain silent. Do you have an attorney?
No.
Did this go through district court, Mr. Vibbert?
Yes, sir. At a court appointed attorney.
Okay, well, I'll continue that appointment. Mr. Austin, could you turn your camera on? This is Mr. Michael S. Vibbert. Mr. Vibbert, you have the right to remain silent. The grand jury of Monroe County has returned an indictment charging you with trafficking in controlled substance first degree, possession of controlled substance in the first degree, being a persistent felony offender, and possession of drug paraphernalia. I'm sending that indictment back to you, Mr. Austin. Do you acknowledge the identity of Mr. Vibbert?
Yes, Your Honor.
Receipt of the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, we will set this for negotiations on February the 11th and the next court date on February 17th. Okay, thank you very much. Is Joshua Vincent next? Is that correct?
Michael Williams.
Michael Williams, okay. Commonwealth versus Michael Williams, 21 CR 0013. Are you Michael Williams?
Yes, sir.
Okay. You're here today for arraignment. You have the right to remain silent. Do you have an attorney or or are you represented by public advocacy in district court? Or do you have a private attorney?
Judge, that's mine.
Okay. Mr. Garrett, you have a right to remain silent, Mr. Williams. Grand jury of Monroe County has returned an indictment charging you with first-degree sexual abuse. You understand that charge?
Yes, sir.
And Mr. Garrett, we will forward you a copy of the indictment.
Yes, sir.
Okay. All right, where are you at now, Miss? You're at home, right?
I'm at home. I'm in quarantine, Judge.
Yeah, I understand. I'm gonna hand it, give us a number where they can fax this to you.
270.
Getting this down. Hold on.
Six-
Hold on.
six-
Hold on. 270
629
629.
4242.
Okay, we'll fax that over. Do you acknowledge the identity of Mr. Williams? Receipt of the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
I do, Your Honor.
We will set this on February the 11th for negotiations and February the 17th for the next plea agreement, for the next plea day.
We addressed the issue of bond.
Sure.
Judge, this is a case where he was indicted in April of 2021. At that time, he was wearing an ankle bracelet for a related case out of Tennessee. He had been wearing that bracelet since August of 2020. He is out on a partially secured $75,000 bond in Tennessee. Previously, this court had set upon indictment a $25,000 surety bond. I would ask the court to reimpose the $25,000 surety bond. If he's released, he will have to go back on the bracelet for Tennessee, and we're totally okay with whatever conditions the court imposes. He's a resident of Salina. He's already signed a waiver of extradition as of January 13th.
Two things, Your Honor. I'd be concerned about the surety bond. He'd have to have a Kentucky resident sign that. It's worth $25,000.
Yeah,
because he lives in Tennessee. And because of the nature of the charge, it's a sex abuse case. I would think a secured bond, property or cash or something would probably be appropriate.
Does he have someone in Kentucky that will sign a surety bond for him?
Judge, I believe there would be a family member to be able to sign something for that, for him.
A Kentucky resident?
Yes, he's got some other family in Scottsville. I would just ask the court to lower that if it's possible, maybe to $10,000 surety.
I'm not gonna lower it.
Okay, I think he'll.
Let me finish here, okay? I will put him on a $25,000 surety bond with an ankle bracelet.
Yes.
No contact with any alleged victim.
Yes, sir.
And not to be alone with anyone under the age of consent, not to be in contact on the internet or through any social media, anyone under the age of consent, okay?
Yes, sir.
If he makes that bond, he can be here for negotiation on the 11th and back on the 17th for his next court date. Okay.
Thank you, Judge.
Thank you. Now, do we have Sky Williams there?
Yes, Your Honor.
17. See if you can find the plea. It's in there. Commonwealth, Kentucky. Okay. Commonwealth of Kentucky versus Sky Williams, 18 CR 00169. Are you Sky Williams?
Yes, Your Honor.
Your birth 1985.
Yes, sir.
Last four digits, social security number 4405. Is that correct? Mr. Bell, have you and your client gone over this pre-sentence investigation report?
Yes, Your Honor, I have reviewed it.
Okay. Is it substantially correct?
The only issue I would have with it is his time, Your Honor. I'd like to have some clarification on that, but I don't think that would bother us today.
Okay. Okay. Trafficking in marijuana enhanced by PFO second degree, 10 years. Possession of controlled substance, 3 years. Drug paraphernalia, 12 months. The misdemeanor will run concurrently with the 13 years on the other two charges, with the 10 years and 3 years running consecutively. $500 fine, which will be waived, and court costs, which will be waived because of length of sentence.
Would the court consider probation for Mr. Williams in lieu of the jury verdict, Your Honor? I do have an argument for that.
Well, you can go ahead and proceed.
Your Honor, Mr. Williams was out on probation for in excess, I believe, of 3 years. During that 3-year term, he never had one infraction. There was no dirty drug test. There was no failures to appear, no failures to call into probation. He did have a residence set up in Warren County. He's moved out of Bowling Green. He's no longer within that environment. And Your Honor, I do know of, and I'm assuming the court would probably know too, of Mr. Williams' environment is being raised when he was a child, Your Honor. That wasn't a great environment to be raised in. I know that he's.
I don't know anything about that. No.
Would you want to testify to that, Sky?
Well, let me tell you something. A jury found this verdict, and what was the offer that he turned down? Didn't he turn down probation?
Yes, sir.
So, I would have gone along with that, but now a jury has put its print on this thing. And if you want to file a motion for shock at some particular person, I mean, he's got a right toward the end of the time period that he's serving to file a motion for shock probation, but I'm not going to overturn what the jury did.
I'll file a motion, Judge.
Okay, thank you very much.
Can I say something?
Sure.
The plea.
It's okay if it's okay with your attorney.
That's fine with me, Judge.
The plea, it came like 2 days before trial. My mind wasn't in the right place. I couldn't even process it at the time. I'd been out for 3 years, a little over 3 years. I never got an offer.
Well, you discuss that with your attorney, and he can put that in your motion for shock probation. Okay. Okay. Thank you very much. Okay. The jail. Who do you have next?
I have Mr. Damian Hamilton, Your Honor.
Commonwealth, Kentucky versus Damian J. Hamilton, 21-00120. Are you Mr. Hamilton?
Yes, sir. Yes, sir.
You're here today for a pretrial conference. Our last 4 digits are Social Security 1940.
Yes, sir.
Okay. Mr. Austin, are you representing Mr. Hamilton?
Yes, Your Honor.
Y'all have an agreement of any sort?
I just got an agreement, and I believe my client will want to take it, but I need to go over it with him. I just received it while in court.
Well, I'll pass over that, and while I'm doing some other things a little later, you can have an opportunity to get a hold of him. And Mr. Hamilton, he'll need to talk to you privately, so we'll put you in what they call a side room later and let you have plenty of time to talk to your attorney, okay? Okay, Ricky, is Ricky Hammer there? Who you have next?
I'm done with all of these, but I've got Mr. Neal here, and did you want to see Mr. Hendrick? Did you receive his paperwork?
Okay, you got Mr. Neal.
Yes, sir.
It's just the deal.
Okay,
How you doing, Mr. Stockton?
It's just the same. Okay.
Danny Neal.
Yes, sir.
Okay. 21 CR 00070 Commonwealth Kentucky versus Danny Neal. It's a motion for shock probation. Is that correct?
Yes, Your Honor.
Okay, what do you have, Mr. Austin?
Mr. Neal has been in custody since he's been arrested. He would
How long has that been?
I've been judge since June the 12th of 2021. And
Wait just a second. Go ahead, Mr. Austin.
Would you like to testify, Mr. Neal?
Yes, sir.
Raise your right hand. Mr. Neal, you swear the testimony about to give us the truth, whole truth, nothing but the truth.
Yes, sir.
Go ahead.
How long have you been incarcerated?
I've been here since June the 12th of 2021.
You have not been pretrial released at all?
No, sir. I was supposed to went to a parole, but I didn't go because the bond, I couldn't get my motion director car, as I told the judge. And I've got some kind of contusion on the back of my neck right here.
Wait. We'll get to that part. If you were released, would you be able to pay the restitution in this case?
Yes, sir.
You believe you would be able to pay it all at once?
Not all at once, but as the tax season come up, I can file my tax, have it done. As soon as I get it done, that's all I got waiting on me, you know. And I got a job when I get out of here, but.
And you'd be able to make payments off of your income from that job as well, right?
Yes, sir. I intend to pay it all, and I don't want to go back to Monroe County, none whatsoever. I will mail the payment.
You did express some medical concerns to me last time we spoke.
Sir, I've got a knot on my back, right in the middle of my spinal cord. That's every time if I move or push it, it tries to paralyze my legs. But you know, I mean, I guess comes getting old age. I just turned 49 years old. I'm tired of the trouble. I just soon lay back and live the rest of my life. My dad, he's in bad shape right now. Didn't do anything. You know.
Does your father have anyone that can
Mr. Stockton, Mr. Stockton?
Yes.
What's your position on this? What's the underlying charge?
It's theft by unlawful taking. He went into Bruton's and had an armful of stuff that he got caught with. And my biggest objection is, and I can see why he doesn't want to come back to Monroe County, because in Barron County, since 1997, I lost count. He's had 8 or 9 felonies, beginning with sexual abuse, then robbery, purse snatching, multiple theft felonies. And it doesn't look like he's ever learned a lesson. And you can shock him, but I have no confidence that he'll make probation because of his criminal history. I was quiet for you, Mr. Neal.
I'm sorry.
Based on his track record. And the sad thing is, the state has pretty well decriminalized these property crimes anyway. I give him a 5-year sentence. He's going to be paroled in a year and back at it again. Even if you don't shock.
Well, I'm not inclined to enter shock probation because of the nature of this situation here. And I do think he would be better served himself to be paroled than he would be shock probated.
Judge, my dad's in bad shape, Judge. Please.
I'm sorry about that, but okay. Thank y'all very much.
So my shock was denied?
Yes, it is, sir. Yeah. Who do y'all have next?
Hendrick, did you get his paperwork? I had him to fax it over. His guilty.
We have the paperwork.
Okay.
Who we got here?
Jesse Hendrick. The one I failed to get one of the documents signed on.
I'm gonna try to find him here. Commonwealth, Kentucky versus Jesse Hedrick, 20 CR 0032. Mr. Hedrick, I understand that you wish to enter a plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 21 CR 00127?
Yes, sir.
Okay, have you had plenty of time to discuss this matter with your attorney? Are you satisfied with this advice?
Yes, sir.
What do you want me to do?
You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges. You understand that by entering a guilty plea today, you give up those rights. I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I will await the precinct's investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation?
Your Honor, upon a plea of guilty to theft by unlawful taking, be over $1,000, the defendant shall receive a sentence of 5 years, probated for 5 years, supervised. It'll run consecutively with Monroe Circuit Court 18 CR 162 and 2032. He'll pay restitution of $150, and he'll have to enroll and complete the Monroe County Specialty Court Program.
Is that what you agreed to, sir?
Yes, sir.
Anybody threaten or coerce you in any way to get you to do that?
No, sir.
Pleading guilty because you are guilty and for no other reason.
Yes, sir.
Okay, now he's not a state prisoner now, is he?
No.
Okay, so I'll have to order a pre-sentence investigation report to be done by probation and parole. Have him back here on February 17th. The court cost in this matter is how much? How much does the court cost this matter? And what, 215, what was the fine, Mr. Stockton?
Is $150 restitution.
150 plus 215, okay? So you can pay it back upon your release at $50 a month with the first money going to restitution. Okay, and I'll have you back here on February the 17th for sentencing, okay? Thank you very much. Who else do you have there?
We're going to take a small break so I can change them out and bring the others in, if that's okay, Your Honor.
Be fine.
All right, thank you.
We'll go off the record here just for a second.
Your Honor.
Yes.
There is a Terrian Netherton on the Zoom conference. He was quarantined and for COVID. He says he's getting tested today so that he'll have proof of whether he has it or not. I believe he was in contact with someone that had it, but he is on for a sentencing hearing. My co-counsel has gone over it over the phone with him, the pre-sentence investigation. And since he was in quarantine, I advised him to get on the Zoom conference so that he could at least appear.
Commonwealth, Kentucky versus Taryn G. Netherton, 21 CR 0090. Mr. Netherton, will you turn your camera on? You're here today for sentencing. Do you understand that?
Yes, sir.
You had an opportunity to go over this pre-sentence investigation report done by probation parole.
Yes, sir.
Okay, is it substantially correct?
Yes.
Counselor, is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
Okay. On a plea of guilty to failure to maintain insurance required by KRS Chapter 304, he'll pay a fine of $500 plus cost. Upon a plea of guilty, possession of controlled substance first degree shall receive a sentence of 3 years, probated for 5 years, supervised, shall serve 120 days on home incarceration. Court cost is how much? So I'm gonna combine the court costs on the insurance in this case for $740. You can pay it at $60 a month, starting 30 days after your in-home incarceration starts. You can, we have a number from the call on in-home incarceration.
I have Mr. Richardson's number, sir.
Okay, well, you call him and I want you to set up on that within 24 hours. And, or unless he can do it sooner, or if he wants to postpone it, but you contact him, make arrangements within 24 hours and to serve your 120 days. Okay. Thank you very much. And also, Mr. Netherton, you need to contact probation and parole here in Monroe County. You want him here Wednesday?
Yes, Your Honor, that's fine. Before noon.
Before noon on Wednesday, okay?
1 second, sir. Disconnected.
Do what?
I lost connection there for a second.
Okay, you need to be here before noon on Wednesday to meet with a probation and parole officer. Get a copy of your papers, okay?
Okay, Wednesday.
Yeah, before noon on Wednesday.
Okay, before 12.
Okay, thank you very much.
All right, thank you.
Who's already done this Jesse Hendricks stuff?
Am I good to go?
Yeah, you're good to go.
All right, thank you.
Here, I'm gonna have to sign some of that Hendrick stuff. So I need to put. Is there anybody else online waiting to talk to us, or we're going back when they start up at the Barron County Jail?
What about that?
Okay, I got some in here, Your Honor. Tell them your name.
James Adams.
James who?
Adams.
Adams.
Yeah.
Good talk.
Commonwealth versus James Adams, 21 CR 00124. Are you James Adams? You're represented by Mr. Bell. Mr. Stockton, have y'all reached an agreement on this case?
No, Your Honor, we weren't able to meet last time.
Okay, meet on February the 11th for negotiations, and the next court date's February 17th.
Could we address his bond, Your Honor?
Oh, sure.
Your Honor, he's got a $50,000 cash bond. Mr. Adams has work waiting on him, and I would like to state to the court, Your Honor, that the alleged victim in this case, and I think Mr. Stockton would affirm this statement, she has contacted me on many occasions with recanting the allegations against Mr. Adams, and I think she's contacted Mr. Stockton quite a bit about this. I do hope we can get something worked out, and I would ask the court if you could put him on an ankle monitor, allow some surety or something to let him get out and get to work, and hopefully we can get it resolved on the 11th.
I would think two things: no contact with the alleged victim. She has contacted me, and ankle monitor. But surely he could make some kind of secured bond.
Well, I'm all right with I don't believe he's a flight risk.
Okay.
I'm all right with a $50,000 surety, clerk approved surety. and ankle bracelet. Stay away from the victim. Sight, sound, or contact.
Yes,
Okay.
sir.
Okay, thank you very much.
Thank you.
The 11th and the 17th are both conditions of your bond, sir. You understand that? You understand that, sir?
I believe so.
The 11th of February to meet here in negotiations and the 17th for your next court appearance. Is that okay? Do you understand that, sir?
Yes, Your Honor.
Okay, thank you. Who you got next there?
Collins. Seth Collins, Your Honor.
Okay. Commonwealth versus Seth Collins, 20 CR 00080. Are you Seth Collins?
Yes, sir.
Okay, we're here today on a pretrial conference. Public advocacy is on, needs to get on. Okay, do y'all have any agreement on Seth Collins?
I do not believe we've come to an agreement on this one. I believe I realized that this was on a little bit later, so I don't believe me and Stockton have talked about it.
We can set it for the 11th, Your Honor, weather permitting, we'll try to resolve.
There's a motion to revoke on, you want to just put that off for then too?
I would just see if we could reach some kind of global settlement on this, Your Honor.
Okay, what they're saying, Mr. Collins, is they're gonna meet on the 11th to try and negotiate your other case on revocation, this case too, so you could wrap them all up. You understand that?
I do.
The 11th and the 17th.
Any way I can get a bond or anything?
Well, not right now, but it's to your advantage to go ahead and get these days out. They'll be good days. They'll count. Okay? Okay, who's next there?
James Farber.
What's the name?
James Barber.
Yeah, yeah. It's kind of like Cousin Denny here, all these names, you know. Commonwealth versus James Farber, 21 CR 00122. Are you James Farber?
Yes, Your Honor.
Okay, we're here today on an arraignment. You have was public advocacy your attorney in district court?
Yes, Your Honor.
Okay, I'll continue that appointment. You have the right to remain silent. The grand jury of Monroe County is returning an indictment charging you possession of drug paraphernalia, possession of marijuana, operating a motor vehicle while license is revoked or suspended for driving under the influence, and possession of controlled substance first degree. We need to set that over on. Mr. Austin, I'm setting the copies of the indictment over on your desk. Do you acknowledge the identity of Mr. Farber, receive the indictments, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, we'll schedule this for a negotiation on February the 11th. And the next court date's on February 17th, okay? What kind of bond does this gentleman have?
He has a surety bond, but he also has a district court case that has a cash bond.
Okay, if he makes a cash bond at some juncture in district court, recontact me concerning his situation. And, or Mr. Austin, and it'd be just as well if he makes a cash bond on the district court, you contact Mr. Stockton, okay?
Yes, Your Honor.
Okay, thank you very much. Who else do you have there?
Mr. Hammer.
You broke out here.
Mr. Hammer.
Hammer, yeah. Commonwealth versus Ricky Hammer, 21 CR 0059. Are you Ricky Hammer?
Yes, sir.
Mr. Hammer, we're here for sentencing today. Have you had an opportunity to look at a pre-sentence investigation report done by Probation Parole?
I have.
Is it substantially correct?
Yes, sir.
Okay. Counselor, is any reason why this gentleman should not be sentenced today?
No, Your Honor.
Upon the plea of guilty to flagrant unsupport, he shall receive a sentence of 5 years probated for 5 years supervised. Probation shall be supervised until paid in full. The defendant shall pay child support about $206.50, additional $100 toward the arrearages for a total of $306.50 to the Monroe County Child Support Office. The first payment shall be within 30 days of the entry of the plea. And what's the court cost in this case? What? $230 court costs. I'll allow you to pay additional $30 a month along with your $306. So you'll pay $30 a month toward the court cost and $306 toward your child support obligation. Okay? Okay, thank you very much. What do you have next here? Steve Martin. For the purpose of arraignment, Commonwealth, Kentucky versus Steve Martin, 21 CR 0080. Are you Steve Martin? What's your year of birth?
First, 1977.
Okay, and the last 4 digits of your social security number.
7663.
You also are here for arraignment in 21 CR 00105. Mr. Austin, you represent him on all these charges. Mr. Austin. 21 CR 0079 also. Mr. Austin, are you there? You appear to be frozen. Somebody check on Mr. Austin back there. Either he's frozen or has had a stroke. I don't know. Could you check on Mr. Austin? Well, there you are, Mr. Austin. I'm relieved. You'll go back there and see if your machine will work again. Battery went dead. No.
So I got indicted, when I got on the district judge, let me out, I went to treatment. I was in treatment when I got indicted on these.
Hold on a second. I'm trying to get your lawyer involved in this.
All right.
Sure, come on in here. Okay.
Sorry about that, Your Honor.
Okay. Okay, you tilt it a little down. Tilt the screen a little down. There, that, okay. The grand jury of Monroe County has indicted you, Mr. Martin, with escape in the 2nd degree, tampering with a prisoner device, and then 2 counts of being a persistent felony offender. That is in 0010. In 008, the grand jury has indicted you with possession of controlled substance in the 1st degree, unlawful imprisonment in the 1st degree, persistent felony offender on the unlawful imprisonment. And in 0079, you driving suspended operator's license, reckless driving, fleeing or evading a police, speeding, and persistent felony offender. Now I'm handing these to your associate out here, Mr. Austin. You acknowledge the identity of Mr. Martin, waive formal reading and arraignment, receive the indictments are acknowledged, interplea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, he'll be scheduled for the 11th of February for discussion and negotiations, and the 17th for entry of plea or setting the trial. Now, your client seemed to want to say something earlier here. You might want to tell your attorney what it's about, because it might be incriminating to you.
Yeah.
I was in treatment.
Without knowing what you're going to say, I would strongly suggest not saying anything, just because if you say something that's incriminating.
When are you going to contact him?
I will be there to see him at least by Wednesday of next week.
Well, I think he wants to talk to you quicker than that.
I will probably take that. Hoping to be.
Wait a second, Mr. Martin. What are you saying, Mr. Martin? Mr. Martin, did you want to say something now?
Mr. Austin, is this about when I was in treatment? You got my papers. Well, I was trying to contact the judge to get the warrant lifted when I got indicted. And my counselor sent papers to the judge saying I was in treatment. And I just couldn't take care of, so I left treatment to come back to take care of the warrant. But I'd like to be able to go back to treatment.
They'll talk about that on negotiation day on the 11th, okay? And your attorney will be in contact with you, and you can give him all the details, okay?
Can send my bond or something?
I cannot. I mean, the charge you have, including tampering with a device and escape and stuff, you're a flight risk. Okay, thank you very much. And now, who else y'all have there? Okay, state your name again.
Isaac Atkinson.
Isaac Atkinson.
Yes, sir.
Your Honor.
Commonwealth, Kentucky versus Isaac Atkinson, 21 CR 00125. You are Isaac Atkinson.
Yes, sir.
Okay, we're here on a pretrial conference. What do you have, Mr. Stockton?
We don't have an agreement, Your Honor.
Okay, burglary and theft, unlawful taking, disposal over $1,000, but less than $10,000. We'll set February the 11th for negotiation, February 17th for the next court appearance.
Yes, sir. May I say something, Your Honor?
You want to talk about your bond?
Sir. No, sir.
I would advise you not to talk about your case, because anything you say could be used against you. What is it?
It's a favor. I have a child on the way, and my grandma is very sick, and they gave her an extended period of time, and I was wondering if you could have that in mind whenever y'all discuss. And I do have a child on.
What is his bond?
It's 25,000 cash.
And why is that?
That's what it was in district court. There's actually another felony case that he might not have been indicted on yet, if Jesse's familiar with that. It was an enhanced trafficking of marijuana.
We have that one. We may not have that one from the officer yet. That's not ringing a bell.
It all came at the same time.
Well,
yeah, that doesn't mean we got it. I believe you.
Yeah. True.
Yeah, I believe it happened, and you know about it, but I've not got it from the officer.
Mr. Austin, you need to contact your attorney, your client as his attorney, and look into the details of any of these humanitarian reasons why you might need to have a bond made, and contact Mr. Stockton. If y'all can reach an agreement, I'll go along with it, okay?
Yes, sir. Also, I'm still in the jurisdiction of DCS in Tennessee until March 14th.
Okay, well, they'll need to include that in their discussions. Thank you very much.
Yes, sir. Thank you, John.
Nick, next. What's your name?
Bridges.
Your Honor, I'm unable to see Mr. Bridges because he was in a COVID unit.
Commonwealth versus Jonathan Bridges, 20 CR 0048. It's a motion to revoke.
Yeah, he was in drug court and he absconded and was terminated August 19th of 2021. I don't know if he wants to stipulate and move his case along or if he wants to prolong it another month.
Your Honor, I haven't been able to talk to him. When I went to him, he was in a COVID positive unit, and they
Well, we can put him off to next month, but
do you want to stipulate, or do you want
do you want to stipulate means admitting to the violations? You don't have to, you don't have to do that. You don't have to decide it right now. You can talk to your attorney if you want some time to think about it. You know.
Yeah, I'll wait.
Okay. The 17th of February. Okay. Okay, who else do you have over there? Who else do you have? State your name, sir.
Ryan Coop.
Okay. Commonwealth versus Brian Douglas Cook, 20 CR 0050. We're here on a re-enter guilty plea. It says motion for pretrial diversion or Class D felony. What we got here, Mr. Stockton?
Your Honor, this plea was previously entered, and for whatever happened, the paperwork was lost. And I bet we've gotten 10 calls and emails from the Department of Corrections because they don't have any paperwork. And I'm about ready to get a warrant on them for telephonic harassment. But
wait, just a second. Let me check with Megan here.
Yeah.
He entered the plea, was pretrial diverted, violated his pretrial diversion, revoked and final sentence. And an audit by the DOC, they could not find it. So he's already.
Pretrial diverted, revoked, sentenced, and they can't find the paperwork here.
they can't find the pretrial diversion paperwork. And I didn't know if you wanted to have Mr. Cook re-sign it or and enter it or just forget about it.
The DOC says they cannot classify him without the order granting.
Okay, I want you to draft me an order stating the date that the pretrial diversion was entered and the date it was revoked.
Okay.
Okay, and saying that this order shall for all purposes be received by the Department of Corrections, the same as if they had the original entry of the pretrial diversion order.
Okay, we'll do that.
That'll take care of this. That'll get Mr. Cook on his way that way, okay?
Okay.
Okay, thank you very much. Who's next?
Do the best you can on that.
Dustin White.
What's your name?
Dustin White.
Dustin White. Go all the way to the end of the alphabet. It's not always easy having a name beginning with W, Mr. White. I've been, my whole life been to back of the line, you know. Commonwealth versus Dustin White. 20 CR 00071. Motion to revoke probation. What does the Commonwealth have?
Your Honor, this was our motion to revoke probation based on a request from Tennessee who was supervising him. He was charged with domestic violence and evading arrest. Evidently, those charges have been withdrawn down there, and he's on parole in Tennessee, and they don't want to do anything on it. So I'm going to withdraw my motion, if that's all right with the court. If
Mr.
not,
White, Mr. White, is it okay with you if the Commonwealth withdraws their motion and sets you free today?
Yes, sir.
Well, that proves that you're sane, so I guess you can get out. Okay. Okay, hey, you need to be careful. I don't know what happened down there, but you see now what can happen, don't you?
Yes, sir.
Okay, see you later. Be on your way rejoicing.
Your Honor, I'll have to, he needs to make sure he comes and sees me Wednesday at the Justice Center, please.
Okay, come to see the probation and parole officer on Wednesday, Mr. White.
You said what?
You need to come and see the probation and parole officer on Wednesday here in Monroe County.
In Monroe County?
Monroe County before noon to get things set back up for you, okay?
Okay, thank you.
Okay. Who's next?
Benjamin Tooley.
Benjamin Tooley. Commonwealth versus Benjamin Tooley, 21 CR 0091. Mr. Tooley, you're here for sentencing. Do you understand that?
Yes, sir.
Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
It's substantially correct.
Yes, sir.
Counselor, is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
Upon a plea of guilty on indictment number 21 CR 0092, the charge of receiving stolen property, defendant shall receive 7.5 years. Upon the plea of guilty on 21 CR 0093, fleeing, evading, he receives 7.5 years. 7.5 years in the two indictments shall run concurrently for a total of 7.5 years, probated for 5 years, supervised. 7.5 years shall run consecutively with Monroe County indictment number 20 CR 005. Under indictment number 21 CR 0092, he shall pay the restitution amount of $1,500 at a monthly rate of $100, with the first $100 being due 30 days from being released from incarceration. Restitution is subject to the 5% clerk's fee. In addition to that, he should pay court costs in amount of $235, and I'll allow you to pay that at an additional $40 a month, starting 30 days after your release from incarceration. Okay. Okay, thank you very much.
Your Honor. Your Honor.
Yes.
If I can take and make bond, will I be allowed to go home to be with my ailing mother and fix the?
What's your name?
James Adams. Mr. Adams, Your Honor.
Have we already had your case here, haven't we?
Yes, the first one.
Talk to your attorney about it. Did you talk to your attorney? And I said if the yeah, $50,000 surety bond, home incarceration. You can walk out of there, somebody signs, it's worth $50,000, and you put an ankle bracelet on, okay?
Go to my own house and go to fix my water lines for my mother and such.
You can do that if you make your bond. Make your bond, put an ankle bracelet on, and do what you need to do, okay?
Thank you, Your Honor.
Thank you.
The problem is, Your Honor, he's not having contact with the victim and she's living at the marital residence. So that's the problem. I guess.
Can't go around the victim.
If
she moves out.
She moves
no
out,
problem.
my son.
You need to talk to your attorney. This is not, let's make a deal here. Go talk to your attorney. He'll give you the details. So who do you have next?
That's all I have, Your Honor.
Okay. Oh, thank you very much.
Thank you, Your Honor. Have a good day.
You too. We'll go to the rest of the docket here. Shouldn't be long. Okay, Christy Lynn Almond. What's the story on Christy Lynn Almond?
Has she been served? It's an arraignment.
Has Christy Lynn Almond been served? She has not been served, not before the court. Dallas Stephen Bowles.
He's from Clark County, and I sent him an email, but they've never gotten on.
Mr. Collins, could you call Hardin County Jail to see if they'll respond to our kind invitation?
Yes, I will. I'll call there now.
Tyler Brown. Tyler Brown.
We've already,
Okay. Alan Michael England. Did we Alan Michael England? He is not served. Alan
served.
Michael England is not served. We did Damian Hamilton, did we?
no, I don't know if we're gonna do him today or not. The plea papers were supposed to went over to the jail.
Damian will be set for the 17th. Terry Muse,
It was continued. His lawyer was in a trial today.
Travis Paul Wayne Pike. Not been served. Joshua O'Neill Vincent.
He's evading service because he contacted Mr. Austin to let him know he couldn't be.
Have a bench warrant for Joshua O'Neill Vincent. There's an indictment warrant out now. There's a bench warrant too, so I guess. He's been calling in according to office, giving reasons why he can't come in. So that's not nice. Ronnie Vincent.
I thought we had him before the court today. That was a co-defendant of Mr. Scott.
We'll have him, notice him to be here on the 11th for negotiation and the 17th. Send notice, and y'all need to contact your conflict counsel too. Okay, because he was in jail and didn't show up on the docket. Does that conclude the criminal record? Yes. I can't understand what you're saying, man. Come on.
Ronnie Vincent, Jennifer, do an order.
What? Are you on the docket or what do you got here? Civil. Well, you almost went to jail, so you didn't. But good answer. What do you got? Come up here and tell me what you got going on.
Stacy, I thought he was supposed to be on the docket today in his plea. I talked to him, he was ecstatic about the offer, to be honest, what it originally been.
Is he free?
He's free.
We'll have him be here on the 17th then.
All right. He was ecstatic last time I talked to him about.
Well, I would like to see him. It's been infrequently that I have an ecstatic.
We did play paperwork, but I think it's probably on me, we've got to just put it on the docket.
On February the 17th.
Joshua Vincent, we didn't call him.
Yeah.
He could have worn out.
There was somebody in Hardin County Jail that we're checking on right now. Who? Bowles is what you're saying?
Judge, I've been I've been connected to about 5 different people. Nobody answers the phone. I'm gonna call back again.
No, don't worry about it. We'll just get him there. Thank you.
You're welcome.
Okay, well, then we're going to go off the record for just a minute to get ready to go to the civil docket.
I don't anticipate that they're gonna call this first. I don't know how many civil cases he's gonna have on the docket. Couldn't tell you. Let's see. Because they probably have a criminal motion hour in the morning. They do criminal for the day and civil. the other. He's got his microphone muted, so. Again, I don't have any idea how long he's going to give us to argue this. And I'm sure we're going to get the pertinent points to your exceptions brought to his attention orally. I mean, they're all in writing already, so I'm going to assume that he's read those. I haven't got any response filed by Holly. I did get that response late yesterday afternoon filed by the so-called federal court, which I found, he's had 2 months and a day to file something. He waits till the day before at the, what I like to call the midnight hour to file them. I doubt seriously if the judge has even read those. He may have, I don't know. He just went in there and picked out things that you've said that seems to fit his version of what the facts should be, as opposed to concentrating.
Okay, we're back on the broadcast. We, I don't see, Where is the child support docket? Arms versus arms.
This be reviewed Thursday, February 17th.
Okay. Cook versus Blakely. You swear the testimony about to give us the truth, whole truth, nothing but the truth.
Yes, sir.
Okay.
State your name for the record.
Maddie Spears.
And you are reporting to the Monroe County Child Support Office. Case of Blackford versus Cook, 21 C9. Cook has arrears $29,223. Ricky Cook? Yes.
You might want to get around on this side over here. Okay. Talk about counsel. Yeah, like, you might want to stand back away. Yeah.
Cook, we already have arrears $29,223.17. That number is correct.
I thought this was throughout for back in 2011. That was the last notice I had on it, that it was all way back then. And Whitney is likely that went over yesterday to Barron County and verified it, signed papers on state.
That it was transferred to Monroe County election on the Barron County certified this was the arrears when they transferred.
Well, let's just let you take a look at it. We'll put it off for a month.
She's proof you have. Well, I'll wait for the court.
All my doctor's statements showing I'm disabled and all that too.
Anything you got that shows that this should not have been charging against you or that she quit pursuing it, but I'm gonna guess it's Cabinet of Families and Children. That it's for state benefits and pay for your children on your behalf.
See, they told her yesterday it was like $600 on that.
Where's you at?
Transport office in Barron County.
Okay, well, I'll look at it.
Hey,
I'm on my office before court. I'll wait for the day court, February 17th.
February 17th, you're to be back here, sir.
Yes.
Okay.
Thank you, Don.
Yeah. Fox versus Fox.
We asked this be reviewed February the 17th.
It's been on virtually more than any. It's a frequent flyer, right?
But it was never getting a break. It was fair.
Gallup versus Gallup.
Review February 17th.
Heston versus Heston.
Review February 17th.
Hudson versus Hudson.
Let's review this February 17th as well.
Eisenberg versus Eisenberg.
That's February 17th.
Pruitt versus Pruitt.
Also review February 17th.
Reagan versus Reagan.
Review February 17th.
Stinson versus Stinson.
Judge, this is our motion, to change venue.
Granted.
Both parties live in Barron County now, and Ms. Spears gets to send one back to them.
Yeah. I started to take this under advisement, but your strong argument. Turner versus Turner.
Ms. Spears, you're still under oath. You are familiar with case number 74. Case number 14 CI 115, Jalen Turner versus Pickerel. Mr. Turner is before the court for notice this hearing. You have murdered $2,000 as of the time. That find him in contempt, find hurt himself for making a lump sum payment of $1,000 and then remain current of his arrears payment of $400 per month.
Sounds reasonable. Okay, let's, what's the difference? Okay. U.S. National Bank as trustee versus Campbell. Motion to amend.
Your Honor, I'm standing in on that one.
Okay, who you standing in for?
On behalf of the plaintiff, U.S. Bank.
Okay, and who do you represent?
JOB advisor.
Tax lien. No objection to motion to amend.
Thank you, Your Honor.
See if there's an order in there. I'll sign, she'll pull an order and I'll sign it, okay?
All right, thank you, Judge.
Cherry versus Cherry. Hello. Go ahead.
Representative Ms. Cherry, we found exceptions to Commissioner's recommendation that came down in December of this year. We had a hearing in, I believe, July or August of 2020. And for whatever reason, the recommendation was not entered for around 18 months, 17 months, something like that. We believe significant amounts of issues have changed, things that would be important. That would be improper to have that recommendation entered. My client signed that affidavit, some of those issues.
Is this where there wasn't running water?
Yes.
What do you have to say about that?
Your Honor, that's simply not true. What happened was my client.
Come up, get closer. Y'all back away and let him.
My client is a resident of Monroe County. He was renting his family's tenant house or farmhouse. He moved in January, the first part of January of 2021. The house itself did not have a running toilet and sink for about 2 weeks, but 40 feet away from the house was a fully furnished shop with bathroom facilities, and then got proof that after 2 weeks of him being there, it was fully functional. And that was just early this year. So that's
Tell me, just give me some background on this whole thing. Who lives where, where they're from? Just give me, and then I'll let you give your version of it, okay?
Your Honor, they were divorced in December of 2019. The commissioner's recommendations at that time, which were adopted.
Yeah, I don't want to talk legal. Just go back.
One child, now 7 years old, joint custody. Ms. Cherry is primary residential parent. Every weekend visitation, Friday to Sunday with my guy. During the summer, though, they have equal time sharing, 1 week on, 1 week off. Ms. Cherry lives in Lieu County. The current order says that parties are to make an exchange in Hart County at her father's house, which was a halfway point. And so you just tell me when you want me to stop, Judge.
No, it's going real well. Okay.
So in July of 2020, my client filed a motion just asking for slight modifications in 3 areas. One, to change the exchange point to a neutral location. The current order, as I said, was at her father's house in Park County. Second was to make up parenting time, which is not an issue because the DRC did not provide for that. And then the third thing that we asked for was to slightly modify during the school year its weekend time with the child, so that it would begin at 3:30 on Friday and allow him to pick the child up at the school in Lieu County rather than wait until 6 p.m. on Friday. And because he's got to have the child back at 7 a.m. Sunday morning. And because it's Monroe County.
This was where there was religious difference too. They have a religious function different. Why would
They're both Protestant. I think it was
7 a.m. on Sunday morning?
I think it's for church. Get you back in time for everybody for church.
And so we were asking.
What time does church start?
Church starts at 8:36.
See, that was another thing, right?
Geez, that's rough right there.
With him being in Monroe, she being in Lieu, we had time zone changes. So to cut to the chase, Your Honor, what the DRC did, and it was a 6.5 page findings and recommendations, but the only thing that these recommendations do are it changed the neutral exchange point to the Dollar General store in Camden, unless the parties can otherwise agree. But it stayed in Hart County. It was already in Hart County, it stayed in Hart County. But the exchange was to Camden at the Dollar General.
How do you get there? You have to go to Glasgow first, or you go through Edmonton? Glasgow.
The other thing that the DRC recommended, that as long as the child attends the Lieu County schools in person, the father shall pick the child up every Friday right after school lets out in the Hart, and bring the child back to the Hart County location.
Okay.
7 in the morning. That did change the return time.
Yeah.
And then the last thing that the DRC recommended was that if COVID modified the school schedule to where it was a virtual setting, a continuous virtual setting, that my client would have every other week, just like it was summer vacation, so long as he made sure that the child attended virtual classes. But other than that, those were the only modifications, and I can speak to the exceptions, but that's really.
Okay, let me go over your exceptions real quick.
Yes, Your Honor. Thank you. Your Honor, first off, the one of the exceptions to it is just that how long the time.
Well,
period
that
being.
I don't care about that.
Okay.
I want to know what relevant changes you want,
Yes, Your Honor. Well, first off, right now, the petitioner is getting every single weekend. My client has the weekday. So she's
Did the
getting,
commissioner change that?
no,
Let's just deal with your exceptions.
I am, we're asking that, but part of our response when we went to the hearing, we were seeking that to be changed from every weekend to.
Yeah, but what did the commissioner find?
He kept it every single weekend.
Yeah, and so I noticed in your pleading, you said that that keeps her from having any kind of normal weekend relationship, that sort of thing.
Correct, Your Honor.
Okay, now that's one exception. Now what's your other one?
The other one is the petitioner, my client has a law, is habitually late. And she tells me, and she'll tell you, put an affidavit, he's late more than he is not.
Okay, okay,
And so.
I can take care of the late thing. That if he's more than 30 minutes late, she doesn't have to give the child up. Okay, we'll find for you on that.
Okay.
Okay, now you need to keep which one of these you win, which one of them, what's your next exception?
Well, Your Honor, the reason why I was pointing that out is that neutral location that's requiring her to drive. Sometimes she could be driving 30 minutes and then say 30 minutes and he not show up. You understand?
I understand, but that's just the way it is.
Okay. The other issue, she signed in her affidavit that the child rarely comes back in the same clothes or with the same belongings the child leaves her with. And that concerns her about the petitioner picking the child up from school, being responsible for having all the school items back.
Well, I'll put in there that she'll return all the clothes that she comes with. I'll put that in order.
And again, Your Honor, we were just asking this to be sent back for further hearing.
Well, okay, the other issue that, except for the every weekend thing. What? Yeah.
The every weekend was the original recommendation back when the parties were divorced that the court adopted and that Ms. Cherry did not file any exceptions to.
Yeah.
And so our position would be that the DRC hasn't changed anything. It's been that way since 2019 when the parties were divorced, and it should stay in place. There's no change.
Not trying to talk about, we did ask the DRC to change that.
I understand that, but I guess my point, Your Honor, is that that's the way it was originally recommended, and initially there was no exception.
Well, let me suggest something here. I'm just going through a list of things to see if we could, if there was an agreement that he could pick the child up at school on Friday. Okay, if there was an agreement. And if there was agreement that she got every fourth weekend. And if there was an agreement that he didn't have to have the child up there until 8 o'clock on Sunday morning, and that he shall have the child clean, the child be clean, ready to change clothes. That's 30 minutes before church, correct? Is that 30 minutes before church? Okay.
30 minutes from the start of church.
Well, I just think it's unreasonable for someone to have to bring a child up there at 7 a.m. and that's 7 a.m. fast time, right? They on fast time there?
That's 7 a.m.
Eastern time.
Central time.
Central. Well, we're on Central here. We're on the same time.
It's
Some-
8 o'clock. Eastern.
Well, where are you going? Where are you going on Eastern time by?
She lives in extra time.
We live on Eastern time.
Well, that's what I was asking her.
Yeah, it's 9:30 Eastern time zone.
Well, here's the thing about it. You can't have somebody deliver a child up there at 7 a.m. She have to get up 5 o'clock every Sunday morning. That's unreasonable. Maybe she comes dressed for church or something if you got 30 minutes. So now if I did those things just like that, what's left unanswered?
Nothing from my perspective.
Okay, would there be anything left unanswered from your perspective, Mr. Carter?
I guess not unanswered, Your Honor. I would think to address the concern of the child having to be up so early, if it became a more traditional alternative weekend schedule, that would also cure that.
Well, then he's gonna have some time during the week and stuff. If you want to have a more traditional, I'm sure he'd probably go to a more traditional thing if he got some time during the weekend. But that's quite a distance between the two of them. It would appear to me than having the child be there all during the week and having a stable situation. I'm not going to go with this if they do virtual. I'm not going with that, because if anything, there's more responsibility on the mother during virtual than there is for someone to have some consistency on instruction. Good luck with that, by the way. But I'm just not going to do that because, well, court takes judicial notice of what a mess it is to keep up with that. So why don't you step out with your clients just for a second and see if what I just said would be agreeable. I won't split it up on the virtual thing. I'll give you 1 weekend out of every 4. He doesn't have to have the child up there until to 8, And what was the other thing?
I think it was 30 minutes late.
At 30 minutes late, you walk, you take it there. Okay. And if he doesn't show up, I'll tell you, if he doesn't show up and you need to validate it in some way, you need to find some way to validate it. And he will forfeit his next visitation if he doesn't show up without notifying you before you leave home. That way you don't have to come back to me every time. You know what I mean? So in other words, if he doesn't text you and tell you that he's going to be 15 minutes late, 20 minutes late, whatever, if he didn't contact you in time for you to not have to leave and sit down there, and he's got a 30-minute grace period. Okay. And so once you all step out, talk to your clients, see if that's agreeable. If it's not, I'll take some testimony if you want to and make a fine. Okay. Okay. Mattingly versus Mattingly. Hello. No, there's nobody else reached an agreement today, and y'all are not going to violate. Okay, will you reduce it in writing and then get it to me? Well, you never know. Things change. Okay, thank y'all very much. Pedigo versus Pedigo. And Mr. Carter has this case, so. You always want to have a seat there and there, right behind you there. DOT Capital Investment versus Bobby Wood.
Your Honor, this is
Yes.
Justin Ramey on behalf of the plaintiff. It's a motion for judgment.
Okay.
I have the objection to the motion to dismiss or the motion for judgment. I do have one.
You need to speak up so they can hear you.
Can't take this.
No, just speak up.
I do have one issue. We've got a motion to dismiss the wife of Bobby Wood, Mildred Wood, as she's deceased. I don't see any averment in here as to whether or not he is remarried, and that raises a concern for if this goes to the master commissioner. So,
Is he remarried? Anybody know?
I'm unaware, Your Honor.
Well, let's amend it and say to unknown wife. I guess you need to give some kind of notice. I mean, do you usually get a warning order attorney for an unknown wife, or what do you do?
that's what I typically do, Your Honor, and I'm not trying to throw anything in the works here. I just want to make sure that it's taken care of before it goes to the master commissioner.
Your Honor, it looks like Miss Wood passed away, and so her interest would have passed to Bobby Wood's joint with right of survivorship, and so her interest would be extinguished at that point. So we're
No doubt
asking.
about that. What he's saying though is there could be some dower courtesy or marital interest, which are created in a new wife, is what he's saying.
I understand. I got you.
Yeah. So, is there any other issue other than that?
That's the only issue. I see.
How long does it usually take to serve someone? Oh,
They get a 50 days to file the report.
well, they can file a report quicker than that,
They
can't they?
can, yes. It's not been my experience that happens.
Well, we can do that. I'm going to appoint, I'll just appoint a warning order attorney, and I get somebody that's just started in a practice that Holly Long Perigin. She's a new lawyer over in Burkesville. She can do one. And what's the minimum days that they have to do? They would have to give them 20 days to answer if they notify them, or what?
Well, so they file their report, and once they know that they have been notified, I would think 20 days.
Well, I would think, but I don't know. I'm just asking you. I've never have really done one like that. Usually you do a report. Mr. Ramey, or what would you think? Do you have an opinion on that?
It's usually 50 days for the report, Your Honor, and then that's considered service by law.
Yeah, I'd hate to put the sale off 50 days for that purpose. So. How long is it going to take you to advertise for the sale? If I sign an order, how long is it going to take to advertise for the sale? Can those two times run at the same time is what I'm asking you.
I don't know, but the judge might be good if the service hadn't been completed. I don't think it would be.
What kind of property is this?
It's just a home.
Well, it's just a home. Is somebody just living in it? Is it
That I don't know,
vacant?
Your Honor. I'm just representing the owner of tax lien.
I know. Well, Mr. Ramey, do you represent the primary plaintiff?
I do, Your Honor.
Who is your client?
Our client is DOT Capital Investments, LLC.
What is it? I mean,
It's a
they buy
tax lien.
mortgage.
It's a tax lien. Yes, Your Honor.
We'll just go ahead and have a warning order attorney done and wait for the report then, okay? Just go ahead. I'll appoint a warning order attorney, and they can, for the unknown spouse of Bobby Wood, right? Will submit me order dismissing Mildred Wood as deceased, okay? And then a warning order attorney on Bobby Wood, okay?
Thank you.
Okay, thank y'all.
Thank you, Your Honor.
Yeah. Go back here and get Nick. Yeah, they don't need to do the Magna Carta back there. I'll call the case of Evans versus Pickerel.
Good afternoon, Your Honor.
What do we got here?
This is to get a new trial date for the case, Judge. We were set for last November and it was continued.
Who's left? Just the former sheriff? Is he the person that's left?
No, sir. He was dismissed by agreement.
Mr. Johns, you need to unmute there. Who's left? Who's left as a defendant?
Billy Pickerel, who was the driver of the vehicle, Judge.
Yeah. Okay. Let me see here. How many days do you think this take to try this thing?
We can be done easily in 3 days, Judge.
I'm not going to do 3 days on this simple case. I'm not going to give you 3 days on it. I mean, what
Matt?
complex issue do you have? What are the issues? Just liability and damages on this thing?
It's liability and damages, Judge. May I ask a question and may help on this? And what's your policy on voir dire? Do you do a general voir dire and then let the lawyers go? And
I do a general, and I don't have a lot of voir dire. You know, I mean, we're not going to do a whole day voir dire situation on this. So.
if I may, I'd not planned on that, but we understand how important voir dire is to the jury trial process, Judge. So I'd like some latitude from the court. At 2 days, honestly, would be pushing it. 2, with the understanding that the jury might get the case at the end of day 2, and I think we're probably in good shape.
I can't hear you, Mr. Johns. Is something wrong with you?
Now, Your Honor?
Yeah.
I'm sorry, my earphones weren't good. I think the court's convenience of 2 days, I think we can, from the defense standpoint, I can make that work without any trouble.
Now, have y'all mediated this?
Yes, Your Honor, we attempted to mediate, and hopefully, I'm still hopeful, but it may not be where we may be far enough apart we can't be successful.
If I may, Judge, we've had 2 mediations in this case.
Yeah, but you just got one defendant left. That right?
Well, I hear you. I don't know that another mediation would be fruitful except for this. And I broached this idea to you several years ago. And that is, if the court were to conduct a settlement conference, we might get this done in half a day and be over with.
Your Honor, if you want to conduct a settlement conference,
it's not that I particularly want to conduct a settlement. It's like, do I want to spend 3 days trying a case, or do I want to spend 5 or 6 hours trying to avoid y'all having to go to the expense? Contrary to what some people think, even plaintiff's lawyers, if they have to try a case, it costs them money. If they could settle it for the same amount, the way I've got it figured, you know, I don't know. Okay, well, let's see where we are here. How many days would y'all need to prepare? I tell you, I could do some sort of settlement day between now and the 17th. And we could, if we can't do it, we could, at that day, we could still set a trial date on whenever we get together. You know, I mean, we wouldn't have to wait to the 17th to set a trial date then. Let's look at our mutual calendars here.
Judge, it would have to be, I've got to get oriented on where I'm at. Are you talking about February 17th, January 17th?
I was talking about getting together sometime in January or early February.
I could do it last week of January, next week. Mrs. Breen is insisting I take her traveling.
Yeah.
For a bit of time after that, but I could do it in mid-February, you know, the week of the 21st.
Let me take a look at that. What does the 16th of February look like for you?
I'll be back. I'm here.
The 16th of February works for me, Your Honor. I'm scheduled on my calendar for trial preparation for a case I have to try down in Paducah.
Okay, well, I don't care about that. Let's just get my little thing here.
Okay.
Do y'all want to do it here, or you want to do it in Berksville, which we do it either place?
What's most convenient for you, Your Honor?
Always, let's do it in Burkesville. Let's start at 10 a.m. That way they'll give you all some time to drive in.
Thank you. Is there anything in particular you'd like to see from us in advance?
No, I mean, you might give me a little fact sheet, this or that, and we just sit down. We can go over it. I don't need a lot of preparation on the thing.
Yes,
That's on Wednesday. We'll use the lower courtroom. They have district court in the upper courtroom. We've got a nice little courtroom on the first floor. So if y'all be there and set up at 10 a.m. and maybe we'll see and what we can do. If we can't reach some kind of accord that day, we will set a trial date that day. We'll all be there to do that. Okay.
excellent. Thank you, Judge.
Thank y'all very much. Bye.
Thank you, Your Honor.
Bye.
Bye-bye.
Okay, Mr. Carter, this case I've called here is yours, right?
No, Your Honor, this is a non-contested.
Well, they've lied on you. Somebody's lied on you.
I think both parties will feel like I was their attorney. I suggested divorce form, but I don't think I could ethically represent either against the other.
Yeah, well, y'all want to come on up then? Thank you. You got your other thing underway?
We got it great.
Okay. Let me get this out of the way real quick. Go ahead. Okay, who filed this motion? You come up to the microphone. What's the problem? Raise your right hand. You swear the testimony about to give us the truth, whole truth, nothing but truth. Okay.
On December 20th, Jonathan refused to bring Paisley back her following week for visitation. When we was in here on, I believe it was December 8th and spoke with you, you said to split the holidays. I would have her Christmas Eve, he would get her Christmas morning. He refused to do that. He did file a CPS case, and the CPS worker Anna Villarreal out of Warren County advised him that visitation was still to continue as it was ordered by you, and he has failed to comply with that. On the
Okay, wait just a second. Move over here. You come up. Swear a testimony about to give us the truth, whole truth, nothing but truth.
Yes,
Let's
sir.
talk about the Christmas visitation first.
And I did not refuse to give my daughter back on December 20th. That is the date that I picked her up. She had me pick her up because I was supposed to pick her up the Thursday before, which was on the 16th. And she told me to wait till Monday night to pick her up. And I've got text messages on my phone that actually.
Okay, move over. So is that true? Come on back up here.
On the 16th, when he was supposed to pick her up, she was.
Did you tell him that he could pick her up on the 20th?
I asked him.
No, you brought it up as about the 20th, right?
I asked him if it was okay because the following week she was out for Christmas break.
And but now you don't, are you complaining about that now?
No, I'm complaining because the following Thursday or Friday, Christmas Eve, whatever day Christmas Eve was on the 24th, he refused to return her.
And why was that?
Because she had been abused and assaulted. That's supposedly
Okay.
the husband of hers, and there is currently pending charges in Warren County for it.
Okay. If you believe something went on, you did the right thing reporting, okay?
I've got the pictures with me.
You know, that's not in jurisdictionally, there's something else going on. Somebody else is looking at that. So is there an investigation going on down there?
The investigation,
Is there investigation going on?
no, she advised me that it was going to be closed.
Okay, what do you say about that?
There is by the police department. Because they have to take her to the advocacy center down there and interview her. And they come down and done her report, and we had court yesterday. But
Where do you live?
I live up here in Monroe.
And where do you live? Yeah. And what's your other complaint?
My other complaint is he went, which I don't think you'll have any control over this, but he went and filed a EPO in Warren County against me, but the allegations in the paper that I got on an EPO are not against me. We go We met yesterday.
Has nothing, I have no jurisdiction over that.
We met yesterday and Lieu was not there, so we have to go back on.
Okay, I have no jurisdiction over that. What's your other complaint?
My only complaint is him not returning.
Okay, until this gets resolved, as far as these allegations, is there any place where you can, how much of the time do you have the child? How much have he has the child now?
It was the Monday through Thursday.
With who? With you?
With me, and then the Thursday afternoon to Sunday afternoon with him.
Okay, where's this male individual? Are you married to him or is he just living? Okay, y'all are married. Okay. Obviously, you don't believe that he did anything to the child or you would move out immediately. Is that right? Mhm. How old is the child?
4.
Yeah. Well, what about these bruises on her?
She jumps off her bed. I mean, she's a 4-year-old child. She plays, she runs, she jumps, she falls. I mean,
Evidently, she's told somebody that something's happened.
I don't spank her. I don't let him spank her.
Has she told somebody that something's happened?
She has not told me anything.
Has she told anybody to your knowledge? I'm sure the social workers have said, has the little girl been interviewed and has she told somebody that something's happened to her?
He stated yes, though.
No, I'm not talking about he, I'm talking about who has told you, who has she made a statement to that she's been hit or touched inappropriately by your husband?
She told her dad who contacted CPS.
Okay, but to anybody else, I'm asking if she has been interviewed by anybody.
Yes, she was interviewed, to my knowledge.
Well, I mean, did they tell you what she said?
I was not told anything that was confidential, and I said I could not tell them.
Well, they couldn't tell you what the little girl said.
No.
Okay, do you have anything?
Not really, Your Honor, but she was interviewed twice, once by the CPS worker in my household. Then, like I said, the Warren County detective had me take her to the advocacy center, and they interviewed her there by herself. And the court down there is having, I guess that's the cabinet. The CPS be there at the next hearing.
Well, I'm going to wait and see what happens at that hearing down there. Okay, I'm going to just defer any action here. And are you have a lawyer down there?
No, sir.
Well, you know, you need to get a lawyer. Both of y'all need to get a lawyer and to align this up. And it could very well be that if there are challenges of abuse or that sort of thing, that this case needs to be, they've got a family court judge down there. It could very well that we need to move this in front of that family court judge where they can consider these things that happened more appropriately.
Yes,
You know what I'm saying?
I agree with that.
Okay. So if you get a lawyer, we might just transfer it down there and let them handle it down there where you live and where the child's going to be and where this stuff happened.
I can get one on behalf of the child, I believe. There's a woman that come and talked to us yesterday.
Okay, well, you just tell her that I suggested the case be transferred down there by agreement between the two of you. If she'll send me an order, I'll sign it. Okay? Okay. I hope things even out between y'all. Hope nothing's happened to this child. And if nothing has happened, or if it has happened, either one, you need to be especially mindful. And I don't care how much you think of this man. I don't, if he has done something or hurts that child, I would hope that you would move his ass out of there, if you excuse my language. Because I get pretty mad about that pretty quick. You understand what I'm saying? Okay, excuse my language for saying that. Okay. Okay, I don't need to talk to y'all anymore about it. Okay, just get us an order and we'll transfer it down there. Okay. Tell the lawyer to send one and let your ex-wife sign it, okay? Thank y'all very much. Yeah. Okay. What is that, Lee? We got your all's case here. Okay. Y'all name the case again. What is that? Yes, I already folded it over, went over it. Okay, wait a second here. Yeah, I got it. Double folded it. I'm sorry. 19 CI 0064 Cherry versus Cherry. You want to make a pronouncement and both you parties listen, get behind the podium there.
The parties have agreed to the court's directions here, and I'm just going to summarize, and I can just have the board if you'd like me to.
Yeah.
If Mr. Cherry is more than 30 minutes late for any parenting exchange and forfeits, that the drop-off time on Sunday mornings will be changed to 8 a.m.
Yeah.
Monroe County time, so that
Central time, let's put it.
Ms. Cherry gets the fourth weekend, and there, when Mr. Cherry picks the child up after school on Fridays, the parties agreed that Ms. Cherry will come to the school. There's a laptop issue, so she's going to come to the school, take possession of the laptop.
Yeah.
And then they're going to meet at the Save-A-Lot, which is next door to the school.
Okay. The only other thing was a close.
Yeah, he will, whatever possessions of clothing that she brings to the visitation, he will make sure that they're back when she goes back to her mom.
Yeah. Okay.
And there was, she had asked to make sure that on Sunday morning, the child be clean and ready to go to church.
That'd be good.
The only thing I would add is that it used to be a rare circumstance because the exchange started with school, but there was an agreement. That he knew he was going to be late, he would call in enough time before Miss Cherry had to leave her house.
That's reasonable. That's right. Okay, well, thank y'all very much. Both of you agree to that? Okay, now from here on out, I hope we get a little, believe it or not, y'all have done better than a lot of people. It's hard, living apart and trying to co-parent a child. But I will say this without probably oughtn't to, but it's very important to this child and to every child to know that both parents want to co-parent. Both of you know that. And I find, especially for little girls, to not think their fathers abandoned them, even if y'all don't get along. So it's hard to do. Co-parenting's hard. So thank y'all for reaching this agreement. I'll be here if you need anything else. Okay. Okay. Is there any other case that we haven't addressed on the docket? The Thrall case. Okay. Okay. Thrall versus Thrall. Now, Ms. Coleman, I understand that you've got the COVID.
I do not, sir.
You've been exposed to the COVID.
I sounded a lot worse yesterday, and I was afraid I had it, so I went and tested. But I tested negative, so.
Oh, well, congratulations. I'll just wait for you to drive on over here then. So.
Yeah, I still think I probably have something contagious.
Okay, all right. I thought we had a. Mr. Hurt, I thought that was a still photo of you there for a second, but it looked like you were just dozing. Mr. Hurt, are you there?
He's muted, Judge.
Mr. Hurt? I thought I saw a finger movement there. Let's go. Is Mr. Hurt involved in this case? He is, isn't he?
He's the friend of the court, Judge.
Yeah, Mr. Hurt? We've lost Mr. Hurt.
I think he's trying to get back on.
Yeah. Be careful there, Mr. Mayor. They'll quarantine you for coughing like that.
I understand, Judge. I'm just trying to clear my throat. I'm still hoarse from cheering the Cats on last night at midnight.
They worried me there for a little bit.
Well, the roughest games I've seen, I'm gonna tell you what, they let them play last night, and it'll be like that at Auburn too. It'll be a tough thing. I guess, Mr. Hurt, are you on there now? Mr. Coleman Hurt? Oh, that's wonderful. Probably got a bad signal somewhere. Yeah. Yeah, he must be in Cumberland County. That's what they said. See if I can call him. He was. Well, I mean, it's gonna have to go out once, isn't it?
I'm in there too.
Well, it won't make any difference if we do it now or 1 hour from now. We'll both go out at the same time, okay? The people that operate the door are here and they don't want the liability of anybody going out after they leave is what the deal is. So we'll go out and move our vehicles. You go ahead and pack your stuff up. I don't know what's happened to Mr. Hurt here. I'm going to have to go out and move a vehicle. So if either, Ms. Coleman, could you try to get a hold of Mr. Hurt while I go out and move my vehicle? We got the Sallyport door is broken and they say we have to remove our vehicles. Okay, so I'll be right back here. I understand. I understand what you're talking about.
Nothing else is gonna be.
They just went down. But yeah, they just left and went down toward the basement. You probably just bypassed them.
Starts like, sir, you need to remove your action. I don't see that.
outside. He had one. Well, welcome, Mr. Hurt. Can you hear us now?
I can, Judge. I'm sorry about that. I went a little farther up the road where I've got better connection.
Yeah. That's because you don't have an office yet. So.
Keep my overhead low.
Operating out of the office. Okay, this is a case that we'll start all over. Thrill versus Thrill, 20 CI 00127. I have reviewed the written objections and responses. It appears, Mr. Mayor, your client didn't like much of anything that happened in the commission.
That is correct, Judge.
Have we tried to reduce this case to some decision points yet?
I'm willing to argue them, or I can just send you something in a condensed.
Well, I'd like for us to reduce them to decision points. Now, I've got your document here and I've read it, and it's somewhat, I guess, by necessity, somewhat repetitious when you get down to when you have to explain things. But I'm not saying it was lengthy, but a little longer than Paul's letters to the Romans, I think, so.
Judge, the first draft was 21 pages. So I got it down to 10. So I thought I did a pretty good job.
I think it was single space. So, let's go down. Give me a little background on, I'll let each one of you do it. And then I'll let Mr. Hurt comment on that. Give us a little background on where this thing started and how, and just once upon a time, about a little preamble. Okay.
Right. The preamble on behalf of Ms. Thrall, who's the petitioner in this case, Judge, is real simple. She had a lengthy marriage with the respondent. They produced many children. She was living in Monroe County when he last abandoned the marital residence, with many of the children still living there, even though some of them had reached the age of majority. The two children that this case started out with, Mary and Ruth, has been going on so long now that Mary has now emancipated, so we're down to Ruth. But he left the marital residence in March of 2019 and never returned. Didn't support, didn't send money to support, didn't do anything, didn't send Christmas cards, birthday gifts, or anything of that nature. In 2019.
He still lives here?
He doesn't. He lives now in Illinois.
She still lives. She still
lives in Monroe County. Yes, sir.
Okay.
Okay. In 2019, the cabinet received an anonymous complaint and investigated and decided to have an emergency hearing and placed Mary and Ruth in foster care for several months. During that period of time, Mr. Thrall was notified that they were in foster care. He sent a response back to the cabinet that he had no interest in wanting to see them, visit them, or have anything to do with them, that they were better off left in foster care. In 2019, the children were returned to Ann Thrall, and Mr. Thrall, who at that time had moved from Kentucky to Indiana, filed a divorce action in Lake County, Indiana. Didn't seek custody of Mary or Ruth whatsoever, just wanted a divorce. All right, sometime in April of 2020, a second anonymous complaint was filed and the cabinet investigated and removed Mary and Ruth once again. At that time, Mr. Thrall made no effort whatsoever to attempt to obtain them from foster care and have them come live with him instead. They were in foster care, and the cabinet, in their infinite wisdom, even though the cabinet knew that they had substantiated a physical abuse act by Al Thrall against both Mary and Ruth in March of 2019, that he never denied and never appealed from, allowed them to go visit him for 1 week during, I think, the week leading up to July 4th of 2020. He returned them back to foster care, and then the cabinet, again in their infinite wisdom, allowed them to go up for 2 weeks later in the month of July 2020, with a date certain for them to come back. On neither time did the cabinet ever obtain the consent, either in writing or by hearing in juvenile court, from the mother to allow that. The long and the short of it was Al Thrall simply refused and didn't return the children back to Kentucky after their 2-week visit. And the cabinet allowed them to let him stay up there until the juvenile court let him have temporary custody at the end of December.
Juvenile court in Indiana?
Now, juvenile court here in Kentucky, and that pending action. That precipitated the filing of the petition for custody in this court on December 29th, 2020. From that date, we have not been able to have any contact, communication, or visitation, or any type of custody rights with either Mary or Ruth. Now, the commissioner made a finding of fact that, somehow my client had not been able to communicate with Mr. Thrall. Judge, we have made attempts to do so. They've been stonewalled from the very beginning. Every time we've reached out.
Okay, okay, so that's where we are today then.
That's where we are today.
Okay, Ms. Coleman, would you give the counterpoint to that rather damning recitation of the client?
I'm muted. I don't even know if I'm muted now. Yeah, I guess, gosh, Judge, I don't know even where to start. I think part of it is the fact that Mr. Meredith conveniently stops with the events leading up to a certain point. So just very briefly to go back to all of those, there was testimony that was contrary to most of what was said in these exceptions. Most of this is what Ms. Thrall testified to.
Well, wait a second. I just want you to give me, the narrative that your client sees, rather than there was testimony to that.
Okay, Mr. Thrall, after, I think there were a couple of incidents of him being thrown out of the house by Ms. Thrall. There was disagreement on the length of that, but when he left the home the last time and moved, he was at the very initial part of that, not in a position to take the children because he was fleeing from an abusive.
In 2019 is where you're at now, right?
He was fleeing from an abusive relationship himself from Ms. Thrall. The cabinet became involved in this case in 2019. They filed a petition. That petition was with both parents. And the testimony, what both parents, he completed a case plan with the cabinet. They gave him tasks, he completed them, and they dismissed those cases, Trail 1. And then very soon after that, Trail 2 was filed. And Trail 2 was just against Ms. Thrall. And Trail 2 alleged physical abuse and sex abuse against Ms. Thrall. with these children. He did immediately, he was in communication with the cabinet and communicating with them and working back and forth. They did a visit to see how it went. He wanted to make sure this was what was going to be best for the kids because they did have several adult siblings that lived in the area. He just wanted to make sure being up there was what was going to be best. But when they came up that summer, things went well. He did not return the children, but he did not return the children because the Commonwealth informed him that he had never been deprived of custody. So technically, they couldn't really demand that he return the children because he was custodian of the children. During all this time, Miss Thrall was deprived of custody. They removed her custody in district court. So she did not have decision-making ability or capability and no role as a co-parent because she was not a custodian in any way.
Okay, wait, let me ask you a question.
Sure.
The Monroe District Court took away her custodial rights.
They removed custody. Yes.
That's not, they removed the children from her care, but they didn't make any finding.
Yeah. Wait just a second.
They did, Judge.
That's well here. You're doing your narrative. We'll do our argument. Make a note, Mr. Meredith. You'll get to argue that.
Thank you, Judge.
Sorry, I now lost track of where I was.
The district court in Monroe County removed custody. What you said.
He did file for divorce up there.
And he wouldn't bring the children back because somebody at the cabinet told him he didn't have to.
Communication with the cabinet through all of that. It is not that
I'm familiar with communication with the cabinet. So what they did is said, you don't have to bring them back. You can keep them up there because there's no order that she gets them back.
There's no order that he can't.
He filed for divorce up there.
He had filed for divorce already. He was not able to name the children as the custody issue because Kentucky already had jurisdiction of those children. Kentucky had open active cases with those children. So he was advised by his attorney that he could not double dip and file up there when Kentucky was currently exercising jurisdiction over the children.
So once he got them up there, he could do it.
I'm sorry.
Right? Once he got them up there, he could do it.
He didn't do it up there because she had already filed here at that point. She filed a civil action here.
In district or circuit court?
Yes.
In district or circuit court?
Monroe County Circuit Court. She filed a custody action.
Okay. Okay, now, so there's where you are, correct?
Yes.
Okay, and Mr. Hurt, what kind of investigation have you done into this thing?
Judge, these parties have a lengthy involvement in the court system in Monroe County. I went through the previous files. They have numerous juvenile cases, as was indicated by both Mr. Meredith and Ms. Coleman. I reviewed those. I also went to Monroe County DCBS and met with both of the workers, Ms. Slaughter, who was the supervising worker, and also Misty Morgan, who was the ongoing caseworker. I got copies of the previous hearings. I was appointed about midway through the circuit court action and reviewed those. And I would say I also, and perhaps most importantly, I met with two of these children and interviewed them. The one who is subject to this action here and the older sibling, I interviewed them separately.
You're talking about R now, correct? You met with R.
Yes. I met with R and M. Were the two children that I met with. I guess the older of which is now emancipated, but I interviewed both.
So R is what we're talking about now.
Yes, that's correct, Judge.
How old is R?
She is a teenager now. I want to say 15. Is that right? I believe. And she is. I will say she's in high school now, and I will tell the court, in my opinion, the Domestic Relations Commissioner got this one right. And the distinguishing feature for me when looking at the history of this case was, it is true that both of these parents, frankly, have made poor decisions over the course of raising these kids. However, the distinguishing feature for me is every single time, without equivocation, and I can tell you the cabinet will say the same thing, is when a case plan has been opened or a court case has been filed, Mr. Thrall has made himself amenable to the services of the cabinet. He's worked his case plan. He's done what they've asked him to. They've been able to contact him. He's been able to, provide them access to anything that they've wanted. He's completed his case plan to the satisfaction of the cabinet. And there was extensive testimony about the petitioner, Ms. Thrall, to the contrary. And that's the view of the cabinet as well, that she has never, to their satisfaction, completed a case plan. She has never been willing to do what they felt was necessary to make them, I guess, satisfied that the child would not be in danger. And I would just add that some of the allegations against her, and in fact, some of the substantiations were more than just normal dependency, abuse, neglect. In fact, when I interviewed R, one of the things she reported was excessive discipline, things like slapping directly to the face, the children being locked out of the home, including some sexual abuse. It was very, very disturbing, some of the things that that she relayed to me, and that those were also investigated by the cabinet. I will say, I believe it's the cabinet's position that these children needed to be with the father during this period that they were with the father. And without speaking for them, I have spoken to them, so I can just relay to the court my investigation. That would be the view of the cabinet. I'm confident of both Miss Morgan and Miss Slaughter, is that the only party in this case that could ensure the safety of the children at this point would be the father. And I don't think any of us closed the door to the father or the mother having, something in the future. But my view, and this is what I recommended in my recommendation to the DRC, and it's substantially the same as what he proposed in his proposal to the court, is that the mother needs to do those types of things. She needs to work a case plan or some type of similar evaluation to show that she's amenable to those services. Because to date, I'm confident that is not the case.
Okay, Mr. Meredith, you've heard what Ms. Holman said and what Mr. Hurd had to say. What relief is it that your client wants ultimately, without going through the exceptions and this and that and everything? What does your client want?
She wants custody of R because by everything that's in the record, she has met all of the requirements in KRS 403-270, and Mr. Thrall has met little, if any. And Judge, I don't need to go through them because there's 6 or 7, and I'm sure you've gone through them, KRS 403-270 subsection 2 many times over. But let's just start off with what we do know. Number one, 3 weeks after M and R got up there for their so-called second visit, M attempts to commit suicide. Now, if this is supposed to be somebody who's taking care of the children and providing a better environment for them, then the cabinet is afraid of.
Before we get into that, my question was, so your client will be satisfied with nothing short of full custody of R?
That's correct.
Okay.
And
what if R doesn't want to live with her?
Well, let me just make a couple of comments in directly relationship to what Coleman Hurt just said. First of all, I was shocked that they didn't bring R down here to testify. There has never been any input from R whatsoever before somebody that could cross-examine her on what her feelings are about who she should be living with. There was no adjudication hearing conducted in front of the juvenile.
Did you talk to R on the phone, Mr. Hurt?
No, Judge, I talked to her in person.
Where was she at in person?
In the Monroe County Justice Center.
Okay. Okay.
So, I mean, they could make her available to come down and talk to him in his capacity as friend of the court, but they didn't have her testify at this 1.5-day hearing that we had conducted before the DRC.
Mr. could have subpoenaed be there just as easily as anybody else. Her presence was not requested at either hearing day.
But that, Judge, we were able to meet our burden. We had several family members testify about the interaction of what Ann Thrall had with R throughout her life, how she had provided the food, clothing, nurturement, educational training, none of which Mr. Thrall had been able to participate in, nor could he refute. And Judge, here was a girl who had been homeschooled up until the point that she goes up to Illinois, and Mr. Thrall, without any input whatsoever from the mother, just decides to throw her into the public school system. Nobody from the public school system came out there and testified that she was so-called thriving in that environment. Nobody who lives with Mr. Thrall, even his so-called fiance, came down and testified at this hearing that it's much better for R to be living with him in a one-bedroom apartment, mind you, with a person that he's not married with or married to. And R is having to sleep on a sofa bed in the living room while they share the bedroom together. So yes, my client firmly believes that the proof that she was able to print on in front of the DRC should have supported her receiving custody. And Judge, I'll remind the court, the cabinet is not a party to this proceeding. They could have come up with a case plan if this was still pending in juvenile court. There were 7 different adjudication hearings on the Trailer 2 case set between April and December of 2020, none of which was ever conducted. So by statute and by law, they can't claim that this action is still pending against her as an open case because they haven't chosen to prosecute her on it. So there's been no findings that she's committed any of these so-called acts.
Did the juvenile court change the residence of the child, not the custody, but did they order her out of Mrs. Thrall's home?
No, I think what they did was by default, after the cabinet admitted at a pre-conference hearing in December of 2020 that they had been up there with their blessing for the last 5 months, Judge Costello says, okay, I'm just going to let him have temporary custody.
Judge, I would disagree completely with that statement. I don't know if you have access to that file, but if you would look at Trail 2 and look at the order from April 21st of 2020, that was an order removing custody from Ms. Thrall. And it is silent as to Mr. Thrall.
Find that for me, April 21st, 2020.
It gave the cabinet custody over Ms. Thrall. They removed her custodial rights at that point. And that has
That's
never been.
emergency. That's what it was. It was an emergency removal. That was an emergency removal hearing.
And it stays in place until somebody takes some action to change it. Did anybody ever take any action to change that emergency?
No. In fact, I wasn't representing Ms. Thrall in August of 2020. Mr. King was, but I saw a note that Ms. Coleman said that she was going to intervene on behalf of Mr. Thrall to seek custody, but she never did.
And I will just say I at that point had spoken to all the attorneys involved and where they were in the case and made the decision that it would be best for him not to actually intervene as a party. So. And the other thing I would disagree with as to his statement is that nobody testified that she was thriving. The cabinet testified to that. The cabinet stayed in contact with this family. The cabinet still has an open case with this family. So that requires them to have at least monthly contact with this family. So I think that they certainly would have been witnesses that you could give adequate weight to as to their beliefs on the well-being of the child. Mr. Meredith likes to, I feel like, mesh the cabinet situation with the court situation. And those are 2 totally different issues. The cabinet has its own set of rules. The cabinet conducts things in a different way. The cabinet can open a case with a family and it never come to court. The cabinet can require a case plan to be completed and it never come to court. So the cabinet can substantiate and it never be adjudicated in court. Those are 2 totally separate issues. And the cabinet testified time and time again at both days of that hearing that they had a case, that they substantiated, that they tried to work with them. There was just overwhelming testimony to that.
Judge, in rebuttal, I'll be glad to argue this point. First of all, the cabinet's not taking away your judicial role of deciding what's in the best interest of this child. Under KRS 403-270, they don't have that role. And second of all, Judge, both of the members of the cabinet who did testify before the DRC both readily admitted they had not personally gone up to Mr. Thrall's residence in Illinois to conduct any in-home investigation of same. They hadn't discussed anything with their teachers. They hadn't gone to the school system. They hadn't done anything.
Well, they would usually go to their corresponding agency up there to do that sort of thing.
And they didn't do that either.
Go up there and do that.
They didn't do that either.
I'm looking at the order of April 21st. It's pretty bare bones. says child alleges inappropriate sexual touching and abuse. Reasonable efforts were made to prevent the child's removal. And they removed it, the child. And there are no less, they made the finding that there were no less restrictive alternatives. Well, why didn't you subpoena the child to come down and appear before the commissioner? Mr. Meredith?
Because I anticipated that they were going to be bringing
Well, I
one, if
know,
not
but,
both of the
you know,
children
it's-
down here.
Well,
And Judge, it took me 6 weeks to get him served in Illinois with a copy of the petition.
yeah.
I certainly didn't know how easy or difficult it would be to get a subpoena served to bring the child in. And Judge, I didn't find this out till after the fact, but both children came down. They just didn't come to the courthouse.
Mr. Hurt, as friend of the court, do you believe, let's say I take some additional testimony in this case. You've reviewed all the testimony. I haven't had, since I appointed you, I haven't had the opportunity. So you've listened to the tapes and you concur with the commissioner that there was sufficient evidence presented. Do you see any value in taking R's testimony at this juncture?
Yeah, I do agree with the commissioner's testimony. I don't know that, from my perspective, no, I interviewed her thoroughly. And I mean, I'll be honest in what she told me with the court. That may not satisfy all of the parties to hear it from me. So there could be benefit, I guess, in hearing it from her rather than through me. But I mean, I spoke with her about virtually all of these things that are being addressed here today.
And Judge, I would say that I don't even have an objection. They were here because I didn't know if we would want them or not. I chose not to call them because I felt like there was plenty.
It could very well be a strategic decision that you're very well within your rights to do. If you think you already thought you had enough testimony, why would you? I understand what you're
I just
saying.
didn't want to put the children through that. But if the court wants to talk to them, they talked to the judge in district court. There's a recording of that interview. She did interview them in the juvenile case over all of them. She did. And he would happily bring her down.
Mr. Hurt, did you have an opportunity to listen to the tape with Judge Costello?
Yes, Judge, she did meet with this child in chambers. And I think the child's testimony has been pretty consistent. I can tell the court.
With R, you're talking about with R.
With R, I'm sorry. R was very clear when I spoke with her that she wishes to live with her.
I know, but
okay,
it could very well be that she doesn't want to be homeschooled and she wants to be in a public school. Is the reason R might want to.
She is very intelligent and was candid. I
would just ask you about the testimony with Judge Costello. Did you listen to that?
I believe I did, Judge. It was in the juvenile file. Yes.
Yeah. Okay.
Judge, I might just add, we've never had the first opportunity to cross-examine this person. If that's who the commissioner's relying upon, or if that's who the friend of the court's relying upon, we haven't had that opportunity.
Okay. What I'm going to do, I think I carefully read, Mr. Meredith, what you had to say, and I've listened, made notes on what your points are and what Ms. Coleman has and what the friend of the court has to say. I would like, and I very seldom interview juveniles because I kind of take the stance, number one, in law school, they didn't make me a child psychologist, and really had very little, if any, training in interviewing children. I don't even like to, during a trial, I don't like to question them on whether they know what the difference on what truth is, or whether or not, is it sinful, or, all these questions people ask them to establish whether or not they know the difference between right and wrong. But I would like to bring R down to testify And I don't want to do it in the form of an interview. I would like to give Mr. Meredith an opportunity to talk in the presence of Ms. Coleman, considering that the friend of the court has said that she's very intelligent and appears to be able to handle something like this. I do not, however, want her confronted with any party that is alleged to have done anything with her, to have to, her mother staring her down or anything. You understand what I'm saying? Yeah. I could very well enter an order if I'm inclined right now to just stay with the commissioner, but it does bother me somewhat that there could be other factors as to why she says this or why she wants to stay up there that we don't know about, can you make arrangements, Ms. Coleman, to have R brought down at a time that's convenient to Mr. Meredith and to Mr. Hurt and myself? And I will have present with me my staff lawyer, and we'll have a court person. Other than that, we'll do this privately. Okay.
Yep. Somebody tell me when. It would, it'd be my preference that it be, maybe a Monday or a Friday if there's any way that works, because
okay.
Well,
that's the reason. Why don't you look for a Monday or Friday that maybe school is out up there or something, Can you step out and get them on the phone? And
he usually responds quicker by email because I don't think he can always take phone calls at work.
Yeah.
Let me see if I can get my computer to wake up. And I don't really have to, he has never batted an eye. If I tell him to come down, as long as
we need to get a date. We need to get a date. Rather than you just vouching for him, we need to get a date. So,
is Mr. Meredith checking his calendar?
I've got my calendar in front of me.
I've got my calendar here.
Do they go on President's Day? That's the 21st on a Monday.
They do. Or we do here.
I'm just throwing it out. I'm just giving them something.
I'm just gonna try him on the phone, see if I get him. I'm gonna mute. Is it okay if I mute for just a second?
Sure.
I don't know. He answered and then it dropped. I don't want y'all to think I'm trying to.
Hello?
Mr. Thrall.
Hello, how are you doing?
I'm fine. How are you?
I'm
on Zoom with the court and with Ann's attorney and the friend of the court. They have filed some exceptions to what the domestic relations commissioner found. And so the judge is reviewing those. And the judge has indicated that he, in an abundance of caution, he would like to talk to Ruth. So I just wondered if you had any thoughts on when might be convenient for you all to come down for him to do that.
Let me check. I need to check to see when her spring break is.
Okay.
Because we shouldn't wait that.
And then I can bring her down then. Can I get back to you tomorrow?
When is spring break? What's he talking about? Spring break.
He's going to check when spring break is.
Well,
if it's the same as ours, I won't be here.
Well, I know, but when is spring break? What?
Be April.
Ours is April. Yeah.
Yeah.
I think he probably would have.
I want him to pick sometime in February sometime.
You had to tell me a date, and then I just have to take her out of school that day.
Right. Which at this point, I think that's just what you're going to have to do. I mean, it just, we can try to do a Monday or a Friday to minimize how much she misses. And, you know, obviously she'll have a note from the court, so it'll be an excused absence, but I think that's probably what we need to look at, because I don't want this to languish any longer than it has to. So do you have any dates, any Mondays or Fridays that do not work for you all?
I should probably be better for you on Monday because of the time I get off of work,
Okay,
because I can head in on Sunday night.
okay. So, but any Monday would work for you?
Yes, I just did, just kind of notice in my employer, that's all.
Sure. Okay. Well, I will call you back after we're finished up and we'll go over that. Okay.
All right, that
Okay.
sounds great. Thank you so
Mhm.
much.
Bye. Okay. So I guess I would just ask Mr. Meredith, maybe what.
Some
Well,
Monday, well,
Is the court open on Monday, the 21st?
As in like 3 days from now?
No, I'm
No,
talking about
the
Monday, the
21st of
21st of February.
February.
well, at the present time, we have a trial scheduled on the 21st. That's President's Day, but it's a Clinton County trial.
I could, Judge, I could do the 7th if it was, if it would be later in the afternoon.
But we have a Clinton County trial on the 7th too. I mean, it's the only place we ever try any cases virtually. But we've got on those 2 days.
And the 21st, I've got wide open.
That's President's Day. It shows you had a trial that day.
Yeah, the 28th, I've got wide open.
What's the 28th look like for everyone? Ms. Coleman, what's the 28th look like?
I'm looking, sorry. I'm open. I have something at 9 a.m. In Barron Family.
Well, you think your client would rather wait and drive down that morning or the night before? We can
No,
put it,
he come down the night before and spends the night with his adult daughter.
okay.
And if we wanted to do that morning, Judge, that's enough notice that I could give Judge Pence that we could probably push that down her docket a little if you wanted first thing in the morning.
Well, so you'd rather do it early, so you'd rather do it at 9 rather than later, right?
I'll do just because I don't want her worrying or fretting all day, not knowing what, how scary you.
You'd rather do it at 9. You don't have to give me the reasons. I won't cross-examine you for your reasons. We all have our.
I don't have a preference. I'll just say that.
Okay, well, we'll do it at 9 a.m. 9 a.m. on February the 28th. And since that's on a Monday, we can have the full courtroom. As a matter of fact, we might use the small courtroom downstairs, less intimidating.
Is that going to be in Monroe County?
I'll probably do it in Cumberland County. Do it in Cumberland County, okay? And that's at 9 a.m. Now, I'm going to review the file, continue to review the file, and maybe consult with the friend of the court's documents these file. Other than that, the only thing I want to hear is from this young lady, okay? So there will be no more testimony in this case. There's been plenty of testimony, and I know I'm going to try to find what Judge Costello's testimony. I'll have him look for it. I'll advise the clerk to try to find the tape where Judge Costello took the testimony.
She didn't take testimony. I think she just had an interview.
I don't know the difference between those, I guess. So I guess I better swear the little girl, or you'll just say I just did an interview. So
I'll be there for this one. There wasn't any counsel there for the previous one.
Yeah, well, it happens a lot in juvenile court when there's sexual allegations. They just do things quickly, and mistakes are made, you know. That's the reason we have a process.
The guardian ad litem was in on that, which is not. unusual.
Yeah, let me ask you. Now, the cabinet, was the cabinet called? Is the cabinet ever testified in anything in this case? Were they over there and testified in front of the commissioner?
There were two employees. They weren't there in their capacity as the cabinet because they're not a party. They had two
They were
workers.
there as representatives of the cabinet testified. I subpoenaed them, yes. Lori Slaughter and Misty.
It's
Miller.
like if you told somebody out at Walmart what their rights were. Well, I'm just telling you, this is Ken Meredith. I'm not a lawyer now, so you can't rely upon. Okay. Well, thank you all for your patience here today, and I'll see y'all on the 28th then.
Will you
Okay?
enter an order on that, Judge?
If you'll prepare it, I'd be glad to. I'll enter it today. I'm here by myself now. I tell you what, Ms. Coleman, you have access. Obviously, Mr. Hurd is homeless. He's operating out of his car. Mr. Meredith, both of these people, let me go off here.
No, there's nobody there.
I think you may be muted, Judge.
Well, there's no way. I don't know how to go off. What I'm trying to do is go off YouTube here.
YouTube.
Yeah.